Well, hello, everybody, and welcome back to the DUI Guy Live, Raw Law Unfiltered. Today, we are going to be examining in depth the second brief, the second amicus brief that was filed on behalf of Amber Heard just yesterday. If you all have not checked out the first video, I will be including it in a description below. The first brief by the women's organizations, not to hate on them, but that chaotic ruffle of papers was absolutely meaningless, as we discussed yesterday. In amicus briefs, the whole point, the whole purpose of the filing of these is to sway appellate judges. Okay? To sway appellate judges. And the only way to sway appellate judges is with law. And that first brief was replete with emotion. Now, I have not read this. We're going to be reading this one together. So I'm laying fresh eyes on this, just like many of you. Let's see if we have substance in this brief. Arguments of law is what we're looking for. So, with that in mind, let's take a look. As a reminder, what is an amicus brief? We did this yesterday. I'm just repeating it for people who may not have been here. Amicus Curiae literally means friend of the court. I have an interest and I want my voice to be heard. Now, you must also ask for leave of court. You can't just file an amicus brief and expect it to be accepted. That's not how it works. You file it and you ask permission, and the judges get to decide, will that permission be granted or will it not? And Virginia goes a step further. Virginia says, not only do you have to ask permission of us, you have to ask permission from the other party and let us know what they have said. As we saw yesterday, Amber agreed to the amicus brief. Naturally, it's all about her. Meanwhile, Johnny's team declined to accept the filing. So they disagreed with it, for obvious reasons. So generally, in referencing a person or group that is not a party, but has a strong interest in the matter, this person or group will petition the court for permission to submit a brief in the action intending to influence the court's decision. Okay? Now let's look at the parties. This one is a little bit different. Up until now, we saw the law firm in New York. The law firm in New York was the one who participated. Well, they have firms. They have offices all over the world, but they don't really specialize in this type of law. This is not their forte. So we're looking at potentially, if this is going to be, as I understand, a First Amendment argument in support of Amber Heard's argument, amicus curiae type brief, we have three main characters. Yesterday we had like 6 or 7. They were all kind of involved in this. These two are licensed in Virginia. Fletcher, Heald, and Hildreth is the name of the firm. And the lead protagonist here is Thomas F. Urban II. He is a class action, business dispute, defective products, RICO action, and complex mortgage fraud case expert. This is his expertise. That's what he does at the firm for the most part. He has served as National Coordinating Counsel for a drug company in products liability litigation, successfully defended clients in jury trial in Texas, and prevailed in summary judgment motion on Daubert grounds, not to be confused with Daubert. Daubert is a legal standard for experts and using experts in Austin, Texas. Now, experts in the court, nothing to do with this. His other representations include issues involving media and internet companies, antitrust, ketam, toxic tort, sex and race discrimination. So maybe in a way that's how he got involved here. I don't know. Americans with disabilities, attorney ethics, and First Amendment disputes. Notice how First Amendment disputes, even though I believe should be like the leading head of this whole thing, is like an asterisk. It's at the bottom. It's a, by the way, I also do this, which is kind of interesting. From the same firm, our second protagonist is Mark Malonzo. He specializes in telecommunications, copyright, antitrust, and litigation. He drafted and edited opinions, orders, and proposed rulemaking and public notices involving spectrum and interference issues. He collaborated on drafting. Oh, so this is not his first amicus brief rodeo. For the Second Circuit Fair Use appeal about music sampling and researched issues in mobile carrier data privacy and merger unwinding. Merger unwinding is when companies merge and then they decide to pull back apart. I don't see anything related to First Amendment issues, but he may be piggybacking off Mr. Urban. Or maybe it's his first introduction to it. I don't know. Finally, from a completely different firm on the other side of the country, we have Mr. Antonio Sarabia II. He is the founder and principal attorney of his own firm. He's got a firm known as IP Business Law Incorporated. It's a very, very basic website, as you all can see. I think he paid maybe like $500 to get this website up, maybe even less. He is intimately familiar, what his website says, with the vast array of legal issues that apparel and fashion companies encounter on a daily basis. For 8 years, he served as general counsel of Guess Incorporated and has done work for many large companies such as Jones Apparel, Macy's, Pacific Sunwear, and Kohl's. So he understands where. Oh, by the way, I have my trusty my trusty Tugs mugs. God, I will never stop giving love to that man. He's so fucking good at what he does. And sorry, I just realized the screen may have been a little too small. Let me make it bigger. There. So he served on all of these as emerging companies that were only beginning to grow. So he builds companies up. In all phases of the apparel business, he has worked closely with prominent designers and understands how is he getting involved? What is his purpose here? I can't help but wonder, because he's licensed in California. He's pro hac vici into the case. Pro hac vici is a fancy term for, I don't have a license to practice law here, but hey, do you mind if I practice law here for a hot minute if you give me the opportunity? And the courts always do. Like, getting pro hac vici sometimes is as cheap as like a $50 fee as an attorney, as long as you're latching onto local counsel. Okay, so you can't just pro hac vici by yourself. They'll never let you. You will need, like these two guys, Urban and what's his name? Malonzo. Yeah. So, okay. All right. So these are the two firms. This is Mr. IP Law, Mr. Sarabia. All right. Those are the three that have officially signed off on this brief. So without further ado, now that we know our players, let's get into it. In the Court of Appeals of Virginia, Amber Heard, Johnny Depp, we all know this stuff. Opening brief of Amicus Curiae in support of appellant Amber Heard and reversal of judgment. Here are the attorneys that I just mentioned, Urban and Melanzo, from Fletcher, Heald, and Hildreth, and Antonio Sarabia. November 23rd, this was yesterday. And once again, we're confronted with what we all already know and love from yesterday, the table of contents. We're going to start with the table of authorities, the identity and their interests. Basically, you got to start with who we are and why are we here. The source of authority to file, which we already know is comes from Rule 5, and the introduction. And they have many points that are scattered across. There is absolutely, so far from what I can tell, there's no cohesion. They're going to go one by one by one by one and just attack them all. They have 9 points to be made, and they are as follows. We're just going to be reading them. We will address them in turn as we go through the arguments to see, does it have merit? Does it have strength? Does it have the force of law behind it? Remember, when we read the brief yesterday, it was replete with emotion and appeals to emotion, and we have determined that it is a pure PR stunt. So no substance, no value for the Court of Appeals. And again, I will make my best attempt to try and read this in the eyes of a Court of Appeals judge, the way that a Court of Appeals judge will look at this, and see if it has any merit in order to sway my opinion in a case that has already been determined, adjudicated, and is now currently on appeal. I know appellate lawyers, Andrea, please don't kill me. Appellate lawyers don't like this term, but it's true, and she'll tell you it's true. We don't like appeals court because it's known as loser court. Nobody likes to appeal their cases. If you're appealing your case, that's a bad place to be. That means you lost in the court below. You always want to be the appellee, because the appellee is the one who's like, well, okay, I have to respond. I'm not just going to let you win by default if I don't respond. So you never want to be the appellant. So Amber Heard is in loser court because she lost and now she's appealing. Johnny is appealing his too, but he doesn't even need to. I don't think he cares. He just did it as a knee-jerk reaction because she filed. And he's like, well, might as well, since you're going to do it, which makes a lot of sense. So welcome to loser court, Amber. The publication at issue, the Washington Post op-ed. So these are not even like arguments. They're just going to be tackling topic by topic. So first they're going to start with the Washington op-ed. Then they're going to talk about some other negative publications about Mr. Depp. Depp's unsuccessful British lawsuit against the Sun. Then in number 4, they're going to talk about the trial itself. Some post-verdict information, which I'm already getting a little sketched out about. When you start talking about post-verdict, judges usually don't care. They really don't care. What they're interested in is what happened during the trial that will allow us the tools and the weapons to get a reversal. I mean, you're asking us to undo a juror's decision. Tell us why. So after the jury has decided, usually judges don't care. So I've red flag, huge red flag already on number 5, but we'll see. I don't want to judge. Like I said, I want to read it. Abuse, in quotes, can refer to many types of actions, which, by the way, now reeks of the previous brief that we just read. Maybe they got together for a little powwow. I don't know. I guess we'll find out. Intimate partner violence is a significant problem in Virginia and the U.S. Again, 6 and 7 are kind of like, they're even on the same page. So imagine the first one is going to be a paragraph or two, and then it's going to bleed into the next one. Number 8, nearly a quarter of female victims of intimate partner violence do not report the violence because they fear reprisal. Okay, 6, 7, and 8 now. They're literally echoing the brief we covered yesterday. And number 9, the verdict in the present case communicates that retaliation in the form of a defamation action is a powerful weapon against women who report abuse. There we go. So the second half, the first half is going to be potentially First Amendment stuff. The second half, well, we already know. We saw this yesterday. Oh boy, great start. Anna Karenina. Oh, hello, Anna. So Anna is an avid watcher of the channel. Hi, Anna. And said that they have connections. They're a very interesting individual who has provided me with lots of information, and I can't wait to hear more stuff. Absolutely, I'm looking forward to it. Larry, desperate to watch tonight, she says, especially after last night's train wreck, but just had sleep meds. Happy Thanksgiving, or love to Indigenous people. Oh, thank you so much. Happy Thanksgiving to you as well. And happy Thanksgiving, everybody. Okay. Oh, summary of the argument. Okay, so wait a minute. This is the introduction? Are you joking? Wait a second. Your introduction is 23 pages long? Oh, dear God. Again, this is not how you write a brief, y'all. An introduction is at best supposed to be like a paragraph, maybe two. Oh, man. Okay, all right. Let's see. Now we get into the argument. Oh man, this is going to be interesting. The trial verdict is inconsistent with First Amendment principles and precedent. Okay. First Amendment. There it is. This is what I've been waiting for. This is what this whole thing is about. This is what this whole brief is about, is the First Amendment. Okay? The trial verdict is inconsistent. Now, the trial court should have ruled that Ms. Heard's op-ed was protected speech. Finally, we're going to have an argument here. Why? A, Ms. Heard's op-ed was protected opinion. 2, abuse in the op-ed was a subjective perspective. And 3, the alleged abuse, defamation, was not based upon facts that were verifiable. Now, that's a very dangerous, slippery slope to make, because again, the court is going to look at that and go, look, we're not in the best position as appellate judges to determine whether or not truth of the matter is related to these so-called facts. We're going to assume them as fact and defer to the jury. You're going to hear me say this a lot. You heard me say this a lot yesterday. Court of Appeals judges defer to juries because the jury was in the room for 6 weeks. They listened to the testimony. They were the best position. They were in the best position, or most aptly positioned, to determine credibility of witnesses, the veracity of what they're saying. And it's a lot more difficult to assess credibility when you read words on a piece of paper in a transcript versus when you look at them as they testify, you listen to what they have to say, and so on and so forth. Okay? So, not based on facts that were verifiable, this is another big, big red flag. But we'll see. I'm not judging yet. We're only getting started. I'm trying not to let yesterday's brief cloud my judgment. I'm looking at this completely fresh. That's why we're doing it the following day and not on the same day. Statements in the op-ed cannot be the basis for a finding of actual malice. Okay, this is point number 2 under that argument. And 3, no defamatory facts could reasonably be implied in the op-ed written by Ms. Heard. Republication of the headline. So this is their second argument. Republication of the headline written by a Washington Post staffer cannot be the basis for liability. which is a very weak argument. We'll get to why. They're going to be talking about when Amber retweeted and thereby retweeted the Washington Post article, thereby accepting that this is something that she has written. And she admitted at the trial, if you all remember, there was a moment when she was on rebuttal and on cross by Camille. I remember distinctly that there was a moment where Camille Vasquez asks her something and Amber Heard accidentally blurts out, and that's why I wrote the op-ed, like kind of saying, shit. I'll remember that moment. Mr. Depp provided no causal, excuse me, I was about to read that, casual causal, we always get that. Mr. Depp provided no causal connection between the op-ed and any alleged injury. You mean him being taken out of Fantastic Beasts 3 is not an injury? Him not being able to do another Pirates movie is not an injury? Any other countless movies that he could have been in is not an injury as a result of what she said? Interesting. Can't wait to read that. The trial court should have dismissed this action based upon comity. You'll see what that means when we get there. All right. And then conclusion. So now we get to the table of authorities. Let's see. So they cite cases later on, it looks like, a little bit in the beginning too, and of course the trial itself, Depp v. Heard. So we got a couple pages of cases here in Virginia. Other states' cases, federal cases are being cited. Okay, see, I'm liking this brief already much, much better. They seem to be a little bit heavier on the law. We'll see if it comes into play in the action. Virginia rules, Virginia state statutes, and other authorities. Now let's see, how many of those do we have? Other authorities. In the previous brief, we had like 6 pages worth. Here we have 1 page. But wait, there's more. Table of media publications. So you're delving into the media. Oh boy. 2 of these are like Amber Heard stuff. Page 2, page 2.5. Okay. Again, doesn't look good. When you have to include so much extraneous stuff, and they're referencing UK again, UK, J.K. Rowling in the UK. Not a good look. Not a good look. Slap lawsuits. Okay, so they're going to be attacking the fact that it was retaliatory here, probably. All right, well, let's see what we got. The identity and the interests. Who we are and why are we here? The entities identified in Appendix A, which we'll get to in the end, like we did yesterday, who have signed on to this brief fall into 3 primary categories. First, organizations that support a vibrant First Amendment have joined to protect their ability to engage in reporting facts and opinions regarding important current issues, which is threatened by the verdict in this case. Hey, retired Nana. She says, everyone knew it was about Johnny since she started defamation when she went for the TRO. Right. Right. Second, civil rights and women's groups have joined. I wonder if the ACLU is in here. And more women's groups have joined to address the significant diminution of reporting of abuse against women as a result of this verdict. Oh, I would love to see. So in the last 6 months, you have noticed a drastic change. Oh, please enlighten me. Oh my God. Anytime you have statistics and numbers, they're usually lies. Everybody knows that. But we'll see. Again, not judging, just based on what you've said so far. Third, groups assisting persons who have been abused, especially involving intimate partner abuse, have joined to protect their clients from the devastating effect of this verdict. So this is, again, very much echoing what we read yesterday. In addition, respected authorities in all three areas have added their voices to the brief. Interesting. Okay. Now, the source of authority to file, remember, just like I said, just because this has been filed does not mean that it's going to be read. Bottom line. Just because we have filed this, the court still has to agree and say, we accept your filing. The amici have moved for leave of court to file this brief in the accompanying motion. So this is the same language we read yesterday, pursuant to Supreme Court of Virginia Rule 5A:23. The exact same rule, the exact same language, both briefs, identical. Not surprising, that's the way it works. Now the introduction. The amici are gravely concerned that the verdict for Johnny Depp in Depp v. Heard case against his former wife, Amber Heard, casts an enormous shadow over First Amendment law. Intimate partner abuse victims' incentives to report abuse by their attackers, and the ability of Americans to speak out about injustices. Okay, again, we covered this last time, yesterday. This is very, very similar in that regard. Show me the money. Don't just tell me this. I want to see, this is the intro, but show me the money. Where is your proof? Because again, slippery slope arguments are terrible. Policy law arguments are terrible to influence decisions. You can't just be like, look, this looks really, really bad. Can we like mulligan? No, that's not how appeals work. If not reversed, this verdict will have a profound effect on the jurisprudence of the Virginia and of the Virginia? Damn, Virginia, the Commonwealth of Virginia just went from Virginia to the Virginia. Interesting. Will have profound effects on the jurisprudence of the Virginia and further effects on the ability of women nationwide to stand up to their abusers. Maybe they forgot to add the Commonwealth right here. And then maybe they had Commonwealth and they took it out for word reason purposes. I don't know. I just find it funny. The verdict will have a chilling effect on a wide range of commentators. Specifically, the verdict has already and will continue to deter women who have been abused by their partners from reporting such abuse, whether it be among other mental, psychological, verbal, physical, emotional, or sexual abuse. Not only was this a highly publicized trial, but it became a social media sensation, possibly in a manner that was not wholly organic. It is a common tactic. Common tactic. Is it now? Again, throwing accusations without substantiation is not going to bolster your argument. It's only going to detract from it. Where is this fact that this has been a common tactic? Just because this is the most notarized case does not mean that this is common. Show me the money. Show me the proof. I'm an appellate court judge. I want more than fluff. I'm going to be making a decision that's going to be influencing millions of people. Okay, it is a common tactic for an abuser to sue their victims for defamation, re-traumatizing them and impoverishing them through the legal system. We'll see. We'll see how you support this claim, because this is an outlandish and unsupported claim thus far. This problem only worsened during the Me Too movement, and this tactic has accelerated due to the verdict in this case. See some article. That's not authority. That's not authority. Lawyers have noticed a substantial increase in defamation cases involving domestic violence and sexual abuse in recent years. Now, that may be true. I don't know. But this has nothing to do with this case. It's good that the Me Too movement is bringing out a fight in women who have been suppressed and abused for years and giving them a voice. No question about it. So it's no surprise that they've been on the rise. That's a good thing that more people are reporting them. That's a good thing. Okay? That no one is going to argue with that. I think it would be absurd to say that's not a good thing. The only problem is it's when liars get caught in the mix and they try and sweep this net and take care of people who have never abused them just to be like, well, screw you, I can win even though you didn't do anything to me. That's where I draw the line. That's where everybody draws the line. And that's exactly what happened in this case. And if Amber is going to be the poster child for what not to do and who not to be, then abso-fucking-lutely, so be it. That's the way it should be. Between 2014 and 2020, there were at least 100 defamation cases filed by those accused of sexual misconduct, most of which were filed after the Me Too movement began. That's not a very high number. Of the tens of thousands or hundreds of thousands of cases, 100 is like a drop in the bucket. That's a terrible argument. 6 years, 100 defamation cases, that's good. That is really good. That means that false accusers are getting slaughtered. That's the way it should be. Most of which were filed after it began. So again, it's some article, but okay, it's not authority. Equality Now, a rights organization, similarly reports seeing a worldwide increase in perpetrators filing defamation lawsuits against victims of gender-based violence. And still waiting. I mean, I know, it's just the intro. It's a really, really long intro, so brace yourselves. The argument of Mr. Depp's counsel to the jury relied upon many assertions that are nowhere within the four corners of the editorial at issue or reasonably derived therefrom. Once again, when you argue that the opening statement or the closing argument, that's not evidence, and the jurors are instructed that it's not evidence, and if the judge allowed it and there was no objection, the ship has sailed. You cannot backdoor an objection now. That's not how the law works. You must object in the moment. And if you fail to object in the moment, you lose. There's no backdooring of arguments on appeal. Everything is already in the record. The record is built. The defamation by implication doctrine has been so unduly expanded in this case that it will lead to numerous meritless attacks on editorials and other publications that claimants will assert contain implied references regardless of how dubious the implication. What did I just read? One more time. The defamation by implication doctrine has been so unduly expanded in this case that it will lead to numerous, slippery slope. Numerous meritless attacks on editorials and other publications the claimants will assert contain implied references regardless of how, but this was not dubious. This case was very, very clear cut. Where is the dubiousness? Again, assertions without support, but we'll see. I'm waiting. In order to find Ms. Heard liable for defamation by implication, a court must make numerous leaps of logic that are not justified by the actual words of Ms. Heard's op-ed or the reasonable implications therefrom. Requiring victims to defend themselves against such lawsuits without proper First Amendment protections. By the way, this is extremely improper. In a brief to not write out first as F-I-R-S-T is not also just it's minor editorial. I get it, but that's not good. You want to write out F-I-R-S-T, capitalize it. You don't want to abbreviate it, the number one with S-T as first. It's just proper brief writing. But okay. Without proper First Amendment protections will cause speakers to either choose not to speak or to incur significant costs, usually against litigants who have far superior assets. Again, baseless claim. Just because it happened in this case does not mean that it's every single case. And that's where they fail to articulate as to why they're right. So number one, this is still the introduction, by the way. Buckle up. The publication at issue, the Washington Post op-ed, on December 18th, 2018, at least finally somebody got the date right. The Washington Post published first online and then in print an editorial written by appellant Amber Heard with the assistance of the ACLU and her own private counsel. That's the op-ed. Ms. Heard had been invited to become an ambassador by the ACLU and to work with the ACLU on an op-ed to bring attention to gender justice issues. So we picked the wrong face. Oops, not an argument. As well as to galvanize support for changes in the treatment of women who came forward to speak out against abuse. Heard advocated that readers help elect politicians who would assist in fighting abuse and pave the way for better investigations by providing proper follow-through of complaints and assurances of no retaliation. In the op-ed, Ms. Heard explained that because she had spoken out about domestic abuse, she had been ostracized and lost employment as an actress. That's a loaded term. Aspiring actress, maybe? Trying to be an actress? I wouldn't label her as an actress, but that's just me. As the Washington Post later wrote, the op-ed urged readers to support women who come forward with allegations of abuse by taking them seriously and electing politicians who will fight for changes to laws and rules of social norms. Okay, so the introduction of the op-ed itself to the judges, in case they were not familiar already through the case. Remember, this, if it will be read, if, which is a big, big if it will even be read, it will be read after the opening brief for Johnny Depp. Well, let me take a step back. Johnny Depp, Amber Heard's opening brief, basically, because it's filed in conjunction. I forgot that this is Amber Heard's appeal. See, even my brain gets confused as to which stage are we on, right? Because there's two cases running parallel. You have Johnny Depp's appeal and you have Amber's appeal. This is part of Amber's appeal. So Amber's appeal opening brief has been filed yesterday, which I'll get my hands on hopefully tomorrow with the help of Laura B. and some others, and of course the lovely clerks at the Virginia Court of Appeals, who I'm getting to know literally one by one, by the way. So you have that brief. Then you're going to have Johnny's reply, which will come in 30 days, so December 23rd. And then you're going to have Amber's reply, barring any extensions, right? So they're going to read the opening brief, the response, and then Johnny's reply, or Amber's reply, excuse me. See, I did it again. It's going to be like mid-January by the time it's filed, but the judges are going to read those first. Then, and only then, if they decide to entertain the amicus briefs, or the amici briefs, because there's at least two of them so far, and I don't think there should be any more. Because the deadline is passed pursuant to the rules that we read yesterday. The deadline is, it must be filed on or before the day that the opinion brief is filed. That's why Amber requested an extension, because the amici were still working on their briefs. So, and by the way, Johnny doesn't have to respond to these. I know somebody asked me. Johnny does not have to respond to these. He has no obligation, and by not responding to them, you give him less credence. By responding to them, you give them credence, which is completely unnecessary. So yeah, so if the judges choose to entertain them, big if, they will be read at the very, very end, after the main parties have already spoken their piece and the judges have addressed them, okay? All right. The op-ed never mentioned Heard's former husband, Johnny Depp, by name or by reference, nor ever stated that Heard had been subjected to any particular type of abuse. But everybody knew it was an implication. Instead, other than the contested passages, the op-ed merely explained that she had been exposed to abuse at a young age and that, like many women, she had been harassed and sexually assaulted by the time she was of college age. And that's terrible, but it has nothing to do with Johnny in this case. The introduction of the op-ed listed Ms. Heard as an actress and ambassador on women's rights at the ACLU. The op-ed itself contains 2 sentences written by Ms. Heard that Mr. Depp claimed were defamatory by implication. Then, 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And I had the rare advantage of seeing in real time how institutions protect men accused of abuse. Neither mentions Mr. Depp nor specifies any type of abuse: mental, psychological, verbal, physical, emotional, or sexual. The statements on their face do not assert that Ms. Heard was subjected to any abuse by Mr. Depp. The rest of the op-ed addressed the repercussions experienced by women who speak up regarding abuse. The op-ed took a broad view, referring to the Me Too movement and the history in Hollywood of facilitating abuse and punishing women who objected to it. It opined that we are in a transformative political movement in which women's rage and determination to end sexual violence are turning into a political force. Ms. Heard's general description of her own experience was limited to a few introductory sentences at the very beginning of the op-ed that were not associated with Mr. Depp. And that's, by now we all know that that is complete bullcrap. Why? Because she admitted to it. It was about him on the stand. So again, trying to backdoor an old argument is cute, it's nice, but it's going to fail. So that introduction already is detracting from the force of this brief. Like I'm telling you, lawyers like myself, trust me when I say this, lawyers are narcissistic egomaniacs. We love to talk. We love to hear our own voices. We love to just show how much we know. But sometimes we forget that on the other end, there's a person who's supposed to be the recipient of this information, right? And it's not good practice to just spew, unless, again, if this is also being done for PR purposes, which is very possible, we're about to find out. Is this pure PR, or is this actually something that they're like, well, maybe this can sway the judge's opinion? Because this is another avenue, right? An amicus brief has never in the history of the United States, as far as I know, has been used as a platform for women's organizations to piggyback on a platform that's already established, the Johnny Depp Amber Heard trial, and backdoor amicus briefs in order to get an extra bite at the PR apple. Like, that's unprecedented. That has never happened before, as far as I know. This is the first time in history something like this is happening. So if this is another PR moment, then that's fine. We'll know what it is. We'll see it for what it is. But so far we have, what's Zinni? She's playing with a toy. So far, this is just the intro. Like I said, this is just the introduction. We don't really have much to go on yet, so let's keep reading. But the introduction, like I was trying to say, the fact that the introduction is so bloody long, I'm waiting for substance. As a judge, I wouldn't be surprised if they do decide to read it. They are literally going to skim the first 22 pages of this damn thing, because no judge is interested in your long intro. Get to the meat. Tell me your argument. I can't tell you how many times I read an opinion and I skip to the end because I want to see, because the last paragraph and the last conclusion, because judges are the same egomaniacs as lawyers are, only they get to sit on the bench because they got elected or appointed. So that's the difference. It's the same people. They love to hear themselves talk. They love to listen to themselves write. Anyway, all right. While the watching other negative publications. So now we're bringing extraneous things that Mr. Rottenborn read into the record on cross-examination, which did absolutely nothing because they were hearsay headlines of tabloids, and the jury saw right through that. So now let's try and backdoor those, is what it smells like. Let's see if I'm right. While the Washington Post op-ed did not mention Johnny Depp, numerous other publications reported in great detail about his drug and alcohol abuse, abuse of Ms. Heard, and others. Well, wait a minute. Didn't you just say that the op-ed didn't talk about him? Hold on. Sorry. I literally just, my brain just exploded. She'll be apples. Thank you so much. I love your picture. It's apples. Wait a minute. I don't understand. Didn't they literally just say the beginning of the op-ed were not associated with Mr. Depp? However, well, other people wrote about it. So there you go. Okay. All right. And his failure to honor obligations to show up on sets in a timely manner, resulting in financial losses to the studios. Okay, so he made mistakes in his career. How does that have to do with the case? These articles caused Mr. Depp's poor reputation among various studios and others in the movie industry years before the Heard op-ed was published. All right, so this is how they're trying to tie it in. Like, Johnny was already in getting shit canned by these productions. Amber had nothing to do with it. He already did it to himself, is their argument. Ms. Heard was prohibited from entering these into evidence based upon an erroneous hearsay objection ruling by the court. Finally, we get our first request, the introduction to what could be their first argument. The hearsay objection by Ben Chu and Camille Vasquez to excluding these other articles from coming into evidence was improper by the court. And again, you're asking to introduce writings of other people. It's pure hearsay. Even you know it's not erroneous, but okay. Had these articles been admitted into evidence, the jury would have learned about other reporting that would have affected Mr. Depp's reputation. So you're asking hearsay to cloud their judgment. I played with her before I started this, you guys. I played with Zinnia just to get all her energy out. This cat is relentless, I swear to God. She was exhausted. She was laying in the middle of my living room, panting like this, in the hopes of, like, now she's just gonna lay and let me do my live. She's like, no, I'm going to cause as much noise and disturbance as I possibly can. I love this cat so much. Oh, man. Okay. All right. All right. There were, had these articles been admitted, this would have shown. There were reliable predictions that Depp would not have any more. Okay, again, this is just, anybody could write these. These mean absolutely nothing. Like, absolutely nothing to the Court of Appeals. Because any schmuck with a keyboard can write these. That's the problem. That's why Court of Appeals don't care. That's why we have hearsay rules in court to prohibit extraneous evidence from influencing jurors' decisions. Say hello to the Gala sisters who just popped in the chat. How y'all doing? It's good to see you. I was on their channel. We did a live or pre-recording, excuse me, a few days ago, a week ago. Yeah, last week. It premiered on Monday. Go check it out. It's on their channel. And subscribe to them. So these articles, again, any schmuck with a keyboard can write these. That's the problem. That's why we have hearsay rules. That's why we have rules of evidence to prohibit extraneous hearsay information from coming in and influencing jurors' opinions and decisions. This is literally what they're there for. And now you have lawyers trying to argue, look, hearsay should have come in because it would have influenced the jury. Well, no shit, it would have influenced the jury. You're not wrong there. The only problem is this is pure hearsay. No, they're lawyers. They're all lawyers. The three people who filed this are lawyers. They are attorneys. Now, we haven't gotten to who signed off on it. That will come in the end. But you're saying he as in me, not a lawyer, which you need to do some research, buddy. All right. None of these articles were sought to be introduced for the truth of the matter asserted, but rather to demonstrate that other publications contained more damaging allegations about Mr. Depp were more likely the basis of any difficulties experienced by him in obtaining movie roles. And again, the counter is they're prejudicial. Very, very simple, like prejudicial. So that's why the court rightfully excluded them. Okay, this is their argument. Yet, the trial court did not permit the jurors to view these articles, as we already know. All the allegations Mr. Depp now contends were implicit with the op-ed provisions were not only public knowledge, but they had been circulated ad nauseum long prior to the publication of the op-ed. Circulated ad nauseum? Again, what is your basis for stating that? You can see it up in our argument, pages 7 and 8, is not a source. It literally, again, in the introduction, that's still hearsay. I want to see proof, but we haven't gotten there yet. We're still in the introduction. By the time that Ms. Heard published her op-ed, Depp was nearly defamation or libel proof. And any allegation, any alleged implication in the op-ed had little effect on Mr. Depp's reputation. How the hell does someone become defamation or libel proof? Will you please tell me? I don't understand. How do you become defamation or libel proof? You can't sue me because I'm unsuable? I am very confused. Retired Nana says, after he got together with Amber, his addictions got worse to cope. She drank and did drugs too. People seem to forget that. People seem to forget that. Thank you, mad scientist. Referring to the Tug Thug Pimp mug. I love this thing so much. I'm telling you, water just tastes amazingly tasty from that mug. There's something about it. Go get one. It's on Tug's merch channel. Depp's unsuccessful British lawsuit against the Sun. So when he lost in the UK, this is literally the reason that Judge Askarati said, I'm giving you an opportunity to try it with a jury here because you didn't get a fair shake with a corrupt judge in the UK, allegedly. One of the most, damning of the articles published before Ms. Heard wrote the op-ed was written by Dan Wooten in The Sun, a British newspaper, published on April 24, 2018. Dan Wooten, gone potty. How can J.K. Rowling be genuinely happy casting Johnny Depp in the new Fantastic Beasts film? So an opinion piece by a reporter that can write anything, can be any, as we like to call them, keyboard warriors, right? Or, they can literally write anything. The internet is an open source. Just because you work for a newspaper does not mean that your articles are reputable. Look at Kat Tenbarge, for example. Anything she writes is completely meaningless and has no value whatsoever. And she calls herself a reporter. She's just one example that I can think of off the top of my head. But just because you're a reporter does not mean that what you're writing is credible, informative, and most importantly, true. Mr. Wooten expressly stated that overwhelming evidence was filed in the California proceedings against Depp by Heard to show Johnny Depp engaged in domestic violence against his wife, Amber Heard. Again, means nothing. It came from an article. No supporting basis. Wooten explicitly encouraged J.K. Rowling, the author of the Harry Potter book series, and Warner Brothers, the studio making the Harry Potter films, to fire Depp from his role playing one of the key characters in the Fantastic Beasts series. And that's Grindelwald, for those of you unfamiliar. He played Grindelwald in the very, very end of the first one and then in the second one. In response, I'm sure he was missed from the third one. I have not seen the third one yet. If he was in it, I probably would have seen it by now. It's just his character was so invaluable. I don't know how they got away with scrapping him from the third Fantastic Beast. If you don't know what I'm referring to, don't worry about it. Let's keep going. In response to this article, Mr. Depp, through his counsel in the current case, Brown Rudnick LLP, filed a lawsuit before the High Court of England and Wales on June 1st, 2018. By the way, you notice something interesting? This is something that I don't know if we ever talked about yet. This is really curious. Amber Heard has already fired and hired and switched counsel how many times throughout this whole case since she first started? I think she went through like 6 or 7 different teams of lawyers, which says something. Meanwhile, Johnny, in 2 cases, across 2 continents, across many, many years, like half a decade or more, has still maintained the same law firm. I mean, that says something too, if you think about it. Against Wooton and the publisher of The Sun, which we all know, that lawsuit in the UK, claiming irreparable harm from The Sun article. The defendants filed a re-amended defense that relied upon a truth defense, specifically that the claimant, Depp, beat his wife Amber Heard, causing her to suffer significant injury and on occasion leading her to fear for her life. The Sun argued, and again, let me just pause right here. The whole purpose of the lawsuit in the US was because he didn't get a fair shake in the UK. You are continuing to detract from your argument by bringing extraneous facts into the judge's minds. First, you started with tabloids. Now you're going into a case that's been adjudicated not in American jurisprudence. Not a good look so far. The claimant and Ms. Heard, this is what The Sun argued, the claimant and Ms. Heard began living together in or about 2012 and married on 3rd of February 2015. They separated on or around 22nd of May 2016. Throughout their relationship, the claimant was controlling and verbally and physically abusive towards Ms. Heard, particularly when he was under the influence of alcohol and or drugs. The RAD was filed on March 6, 2020. After 16 days of hearing in the case on November 2nd, 2020, Mr. Justice Nichols, sitting in the British High Court of Justice, Queen's Bench Division, issued his judgment, a 129-page, 585-paragraph decision, which found that the statements in The Sun that Depp beat his wife Amber Heard, causing her significant injury and on occasion leading her to fear for her life, were substantially true. This is one person, one man, one judge making a determination about an entire case. Whereas in Virginia, we had 7 independent people. Oh, and by the way, let's not forget, in the UK, the system does not allow victims to be cross-examined. They just bring in their testimony and it's accepted as is. Where in the US, we have cross-examination. So everybody got a chance to see and hear from the horse's mouth. That is a stark night and day difference. That is why the decisions are so vastly different. And also, don't forget, in the US, he sued Amber directly, whereas in the UK, he sued The Sun. So it's bonkers. It's absolutely bonkers that they're bringing this in. In the judgment, the High Court noted that the burden of proof to the civil standard of proof, namely the balance of probabilities, which is kind of like what we have preponderance of evidence, balance of probabilities. I think Canada is similar, balance of probabilities. It's all essentially the same. Standard was on the defendants to establish that the statements were true. The High Court found that the great majority, 12 of 14 of alleged assaults of Ms. Heard by Mr. Depp, have been proven to the civil standard. As a result, again, no jury here. As a result, the High Court dismissed the claim brought by Depp against The Sun. On March 25th, 2021, the Court of Appeals refused Mr. Depp's application for permission to appeal the judgment. More than 2 years after this article, Mr. Depp resigned from this role after losing his lawsuit in November 2020. Sonia Rao, Johnny Depp's dismissal from Fantastic Beasts. There was substantial adverse press about Mr. Depp at the time of the filing of the Sun case by Depp in June 2018 during the hearings and trial in June and July 2020, and after the judgment was released on November 2nd, 2020. Okay. So far, I am not impressed with this introduction. It's very sparse. It's trying to bring in extraneous stuff that has absolutely nothing to do with the case, facts that are not related to what happened in the courtroom in Virginia for the 6-week trial on April and May and June 1st of 2022. And I, as a Court of Appeals judge, am probably going to skim this with very little interest because it has nothing to do with the decision I need to make. It's an appeal to emotion. It's an appeal to, well, look at all this other cute stuff that we have. It doesn't work. It doesn't work that way. Beautifully Damaged says, UK to US, Johnny's testimony never changed. Even movements of his expulse of throwing vodka bottles, expletives, of throwing vodka bottles. Anne-Marie Mitchell says, it's not the sun, it's called the scum. The scum. The judge was so bent he couldn't lie straight in bed. Truth wins always. Thank you for that, Anne-Marie Mitchell. All right. The Depp v. Heard trial. We're still in the introduction phase. To say that the Depp v. Heard trial in Fairfax County Circuit Court and its surroundings was a circus is a gross understatement. So basically, okay, hold on. Now this was written by somebody on Twitter. I know. Here's some spare change from your best friend's bus ticket. Oh, you saw that, Alexander? Yeah, we had some fun on Twitter today. So, okay. Lawyers are supposed to be writing this, not children. Sorry, my foot is being attacked. Lawyers are supposed to be writing this, not children. Calling a court proceeding a circus is reserved for Twitter and your gossip circles off screen. It is not something that you want to state in a amicus brief to influence appellate judges' decisions about a case. I mean, you're literally stating that what had happened is a circus. And even if that's your true belief, keep it to yourself. Don't put it in the brief. As the unofficial video record has shown, the outside entrance drop-off gauntlet through which both parties entered the courthouse and through which Depp was championed and Heard was vilified. So you're giving the judges a taste of the public opinion, which is good, I suppose. And the conduct of the courtroom audience and some of the participants created an atmosphere more appropriate for a trivialized wrestling match than a court trial impacting people's lives. Well, that's what you're going to get when you have a highly publicized A-lister suing a Z-list celebrity. That's what you're going to get. When you have Johnny Depp and AH in the same room, people are going to flock to the courtroom. I don't think this is a My bad, you guys. I hope I didn't scare you. I pressed the back button on accident. I don't think they're talking about me. They're talking about Eve, because I wasn't ever not allowed in the court, like kept out of the courtroom. I was not allowed to get in on that final Friday due to some external interference that had nothing to do with yeah. Mad scientist just had a stroke. I'm sorry. I need to like not touch my mouse so aggressively because it's got the back button on it, and I literally just went back. I hope that didn't cause any disturbance for you all. But anyway, all right. So where was I? I mean, that's what you're going to get. This is a highly publicized trial. What do you expect? You can't just be like, well, can we like close the doors to the public for this one, Judge? That's not going to happen. It's not going to happen. Social media lambasted Ms. Heard and viciously attacked anyone who expressed opposition to Depp. Welcome to the public opinion. Because in the beginning, for 6 years, they have attacked Depp and supported Ms. Heard. For 6 years. And now for 6 months, Ms. Heard is being attacked for her lies, and you're upset with it. I'm just going to sip my water, my tug water. Tastes like victory. Targeted trolling and trend manipulation. So another article written by Bot Sentinel. Oh shit. Bot Sentinel is in this one too. Man, they like to cite him, don't they? Not a good authority. Okay. You're just shooting your argument in the foot over and over, but okay. The lack of decorum was further exacerbated by social media postings, which belittled Heard and heralded Depp. None of which influenced the jury, none of which had anything to do with the bearing on their decision, none of which came into during deliberations, none of which came into the courtroom. This was all outside. Judges don't care. Tell me about the jury. I'm still waiting. What am I supposed to do and why? None of this matters to me. As a Court of Appeals judge on the Virginia panel. The lack of decorum was further exacerbated by social media. Okay. Attorneys for Depp were shown making inappropriate gestures and harassing witnesses when they were on the stand while being praised by the mob. Depp attorney gets rock star treatment leaving court. All of these, this is a YouTube link. Man. All of these elements which are predictable results of defamation suits improperly filed and involving public figures chill speakers who should be protected by the First Amendment. It is difficult to overstate the amount of historical interest the case attracted and its long-term impact. Broadcast of YouTube segments amassed a total of 83.9 million hours watched, with a 3.5 million peak viewers during the announcement of the verdict, I imagine, yes. The opening argument of Mr. Depp's counsel, the evidence presented by Depp, and Depp's closing argument would lead a reasonable juror. Okay, so now they're trying to tie it together. Let's pay attention. This finally comes, at least the hint of an argument. The opening argument, which is known as opening statement, it's closing argument and opening statement. But okay, opening argument of Mr. Depp's counsel, the evidence presented by Depp and Depp's closing argument would lead a reasonable juror to believe that the defamation being sued on by Mr. Depp was not on the op-ed itself, but rather the allegations of abuse by Ms. Heard in 2016 in her California court filings and subsequent press coverage of those filings at the time. So they're saying the jury got it wrong. The jury didn't understand things properly. But you need to tell us why we should take action and how. What is the mechanism that allows us to do so? So far, we still have just an introduction. As Benjamin Chu, Depp's attorney, stated in his opening, which is not evidence, the evidence will show that Ms. Heard's false allegations in 2016 had a significant impact on Mr. Depp's family and his ability to work. Depp's counsel later argued that what is at stake in this trial is a man's life, a life that he lost when he was accused of a heinous crime. YouTube was the only channel that told the truth, says retired Nana. Mainstream could not be trusted. That's why people flock to YouTube to watch people like Rekieta. Shout out to Nick Rekieta, by the way. Let me take this moment to do that. Go subscribe to his channel as well. Phenomenal attorney. Very fun entertainer. Only later did Mr. Depp's counsel correctly argue that this case is about what Ms. Heard said in her op-ed, but then went on to distort what she said, even by implication, which kind of is what Amber's lawyers did too. They started calling it the Depp-Waldman statement, if you remember. This is the pot calling the kettle black. That's the problem. Depp's counsel argued that Ms. Heard painted a picture of herself as a heroic, innocent survivor of the abuse by Mr. Depp, a beaten woman who finally stood up for her tormentor. The evidence will show that Ms. Heard portrayed Mr. Depp as a representative of abusers everywhere, the agent of her suffering, the villain in her heroic journey. All right. Not evidence. Still waiting for the evidence. Again, this is just the introduction. Evidence in the case was presented over 23 trial days. Interestingly, Depp did not introduce into evidence a copy of the op-ed that was the basis for the lawsuit until April 2022, April 20th, 2022, the seventh day of evidence. And his counsel mentioned it only in passing during their opening statement. All right. It's their case. They're the plaintiff's attorneys. They can run their case how they see fit and in the best way that they see possible. This is a terrible argument. This is literally trying to tell the Court of Appeals judges that they should have done things differently. That means Ben Chu, Camille Vasquez, and the rest of the team. That's not nobody cares. During the trial, this is called strategy. During the trial, Mr. Depp asserted that when Ms. Heard made abuse accusations against him in May 2016, these accusations had an immediate impact on his career, saying that when she made those accusations, he lost nothing less than everything. Again, you're trying to object post-verdict. You're trying to backdoor an objection, and lawyers know this does not work. Backdooring objections is a doomed to fail strategy because judges don't care. Give me where the objection was, the ruling, and then I can maybe overturn. Overturning a judgment is still a very, very critical aspect of this whole thing. To ask judges to overturn a judgment, sometimes judges will be like, you know what, this was done wrong. This instruction should have been given, but you know what, it was harmless error. I can't tell you how many Court of Appeals decisions I personally have read where judges are like, yeah, the mistakes were made. Like here, there's a mistake here, there's a mistake here, there's a mistake here. The judge should not have ruled on this. The judge should have ruled this way. And guess what? Verdict stands. Because those mistakes and cause and judgment were harmless error. Remember that word. I feel like it's going to come up a lot when we read the order in this case, probably next November or next December, next year. October if we're lucky. So brace yourselves. It's going to be a long year once all of this is filed. So, yeah. His counsel reportedly argued that Mr. Depp's claims were focused on the allegations that Ms. Heard made in 2016, twice referencing 6 years to the day of the argument. 6 years ago, Depp's life ended. Mr. Depp's counsel began the closing argument. Again, not evidence. So they're arguing not evidence and they're trying to backdoor objections. Not a good look. Not a good look so far. On May 27th, 2016, Ms. Heard walked into a courthouse in Los Angeles, California to get a no-notice ex parte restraining order against Mr. Depp. And in doing so, ruined his life by falsely telling the world that she was a survivor of domestic abuse at the hands of Mr. Depp, period. Today, on May 27th, 2022, exactly 6 years later, we ask you to give Mr. Depp his life back. By the way, now we know where that phrase comes from. The give Amber her voice back. They're actually echoing Camille's give Mr. Depp his life back. I don't know if anybody knew that, but I think this is where it comes from. Give Amber her voice back. She never lost it. She lied. And liars' voices are not echoing. Liars get suppressed by the general public because nobody likes to listen to people lie. People like to hear the truth. So We ask you give Mr. Depp his life back by telling the world that Mr. Depp is not the abuser Ms. Heard said he is, and hold Ms. Heard accountable for her lies. All right. So again, here's the problem. Like I just said, they're arguing not evidence. Thus, Mr. Depp and his counsel asked the jury to hold Ms. Heard accountable for filing the restraining order in 2000 for the TRO in 2016, not for the op-ed. Again, I'm waiting for substance. Waiting for substance. Still the intro. Number 5, post-verdict information. Now remember I said 5 was already a red flag, and then we know 6, 7, 8, and 9 are going to be basically echoing all the stuff that we read about yesterday in the other amicus brief. Judges don't care about post-verdict stuff. They care about what they can do. The chilling effect that this could potentially have, which you're not substantiating, is cute. Maybe you are right. Maybe you are wrong. But at the end of the day, it doesn't matter whether you're right or wrong. What matters is you picked the wrong face for domestic abuse, and now you're trying to undo the damage by backdooring all this stuff in. That's not how the appeals process works. That's not how you get a verdict overturned in a court of appeals. Every lawyer worth their salt knows that. And I'm a little surprised that some of these lawyers, I mean, they come from pretty prominent firms, but it seems like their expertises are not related to appeals work in the filing of amicus briefs, except maybe save of one, who's a fairly young guy who filed this. But again, it's a PR move. It's starting to prove again, this is a pure PR move. This is just so they can take text from it and be like, ooh, look at all these supporters that she's got, which is fine. But this is not the platform for this kind of stuff. Retired Nana says they don't note the Amber violated the TRO. Sorry, this really gets me upset. Don't get upset. This is just legal process and people injecting themselves in a place where they don't belong, arguing things that do not matter, that do not have any influence or bearing on the decision of the Court of Appeals judges in the Court of Appeals of Virginia in Virginia. That's the bottom line. That's the bottom line. And you all can see that. You don't need to hear me say that. You all are reading this with me. You see what I'm getting at. Despite the fact that the identity of the jurors had been sealed, after the trial, one juror chose to speak out in response to various comments made by Ms. Heard and her counsel. Huge objection hearsay, because the jury process is extremely protected. And just the fact that one news outlet claimed that we have heard from one juror who said this, it's like double or triple hearsay. It's a news outlet reporting on something that they heard from someone else. That's double hearsay right there. And you are adding a layer to it. Now it's triple hearsay, triple stacked hearsay. I mean, unbelievable. Unbelievable. The juror said, this is the alleged human, it's not a juror, said that, quote, they were both abusive to each other, but to rise to the level of what she was claiming, there was not enough or any evidence. Good Morning America. The juror further stated that Heard's team failed to prove Depp's abuse was physical, thereby demonstrating the juror's misunderstanding of the burden of proof on this claim and the full scope of the term abuse. And this is what they're really latching onto. Now we see the meat of why this amicus brief was written. This language right here of this alleged juror, they failed to prove that Depp's abuse was physical. Aha! So we didn't do a proper job. We fucked up. We messed up. We should have highlighted more of other stuff, which, by the way, the judge, some of it she allowed, some of it she didn't allow. So I imagine they're going to make the argument that it should have been allowed in greater force and greater depth, but you don't get a second bite at the apple. You don't get a chance to retry the case on appeal. You can only appeal the issues that are already in the record. Number 6, abuse can refer to many types of actions. Here it is. Abuse can take many forms. More than half a century ago, the Virginia Supreme Court recognized the power of abusive language. And that was, by the way, remember, that was originally Elaine Bredehoft's strategy, if you remember, is that, well, maybe he didn't like physically abuse you. Maybe we can go to like emotional abuse. Maybe we can do a little bit of kind of do it like a mix and match. And Amber was like, no, we're going all in or bust. And the all in failed because it never happened. And now she's paying the price. The Virginia Supreme Court recognized the power of abusive language during a relationship. Angry words, coarse and abusive language, humiliating insults, annoyances. Okay, that's fine. It's even a Virginia case. Like, wow, fantastic. Show me the money. Virginia courts recognizing the serious nature of psychological abuse have granted protective orders against. This is starting to sound like against family members, even without the threat of violence. This is starting to sound like what we read yesterday. Very, very, very similar. I'm serious. I think they got together in a powwow and kind of wrote some of this stuff together. It may be the same cases. I don't remember if it was or not. So it's great. They're citing cases, but how does it relate? All right. During his trial testimony, Mr. Depp acknowledged the various forms that abuse may take, including emotional, verbal, physical, and psychological. It would be nonsensical to not acknowledge that those things exist. But okay, so that's just point number 6. No real substance there. Number 7, intimate partner violence is a significant problem in Virginia and the United States. Understanding of abuse, especially domestic or intimate partner abuse, has increased in recent years. There are at least several categories of intimate partner abuse, each of which causes lasting harm and can escalate, according to the Centers for Disease Control in their 2010-2012 state report. The National Intimate Partner and Sexual Violence Survey. Intimate partner violence includes physical violence, sexual violence, stalking, psychological aggression, including coercive tactics, and control of reproductive or sexual health by a current or former intimate partner. The CDC state report supports defining emotional, coercive, verbal, and mental abuse, among others. Once again, we're coming to the whole, this is a poorly written research paper, just like the one yesterday, but I'm going to reserve judgment. We haven't gotten to the argument yet, but just the fact that this introduction is like infinitely long, it detracts more and more. With every word written, every word read, it detracts more and more for the Court of Appeals judge through their eyes. Within intimate partner abuse is psychological aggression, which includes expressive aggression, such as name-calling, insulting, or humiliating an intimate partner, and coercive control, which includes behaviors that are intended to monitor and control or threaten an intimate partner. Similarly, as the CDC explains in that study, sexual violence includes non-contact abuse, such as non-contact unwanted sexual experiences of verbally sexually harassing the victim, making a victim look at or participate in sexual photos or movies, and sexual coercion, e.g. threatening to spread rumors and sexual pressure due to someone under the influence or authority. Okay. The CDC report determined that abuse has multiple types, and recovery from abuse is not only a matter of healing physical bruises, as the report found, while psychological aggression by an intimate partner was experienced by 47.1, again, statistics. By 47.1% of women, physical violence by an intimate partner was experienced by almost a third. Again, trying to bring extraneous things into the judge's purview. Emotional reaction, anticipating an emotional reaction. No real substance. Both of the, again, great information, great to know, but has nothing to do with the bearing in the case. Both of these types of abuse were found to have profound effects on women. Intimate partner abuse of women during 12 months, Virginia and the US, and they're comparing them. Okay, sexual violence, physical, and then psychological. Combining sexual violence, physical violence, and or stalking by an intimate partner. And is this, what year is this? 12 months, just a 12-month period. That's horrifying. I mean, that's absolutely horrifying. 25 million instances across the United States. Isn't that like 1 in 10 people? It's not even 1 in 10 adults. It'd be like 1 in 7 or something adults. That is fucking terrifying if true. But it has nothing to do with the bearing on this case. Combining sexual, there was almost 600,000 female victims in Virginia in 12 months and almost 25 million female victims in the country. I mean, that is staggering. These numbers are absolutely staggering if true. The levels of intimate partner abuse over lifetimes are even higher. The majority of females and over a third of male lifetime intimate partner violence victims have experienced one or more intimate partner violence-related impacts. Commonly reported IPV-related impacts for both women and men were feeling fearful, being concerned for safety, and experiencing symptoms of post-traumatic stress disorder. According to the CDC report, again, I can't believe this is still all intro. Like, I as a judge would be bored by now. Like, I'm waiting. We haven't even gotten to the really, really good stuff yet. Really good stuff yet. Yeah, what about the men? Where's the men, Ashley? Ashley Haynes points out something very interesting. They're not talking about it. In a disclaimer, it said estimated. Is that what it said? Estimates, average annual estimates. Oh, and then that's like 10 years ago. That's pre-Me Too movement, by the way. Society has changed. Society has changed. I hope. They're estimates. They're not even, well, wow. Okay, I take my statement back. They're estimates. They're not even real numbers. Jesus Christ. Commonly reported inner partner violence related impacts for both women and men were feeling fearful, being concerned for safety, and experiencing symptoms of post-traumatic stress disorder. According to the CDC report, sexual violence, stalking, and intimate partner violence are important public health problems that have an enormous and long-term physical and mental health impact on victims. No question. What does that have to do with the case? The CDC report establishes that intimate partner abuse is a significant problem in Virginia and the United States. A recent medical journal study placed an economic value on the losses to American society because of intimate partner abuse, concluding that the losses to the U.S. economy. Oh, so now we're talking about how much money we've lost to that. Okay, oh boy, fantastic. Concluding the losses to the U.S. economy, lost wages, impaired health, property damage, treatment costs, and lost productivity caused by intimate partner violence are more than $3.6 trillion over the victim's lifetime. Wow, so now we're going to every single individual estimated victim multiplied by all of this stuff for their lifetime. How is this relevant? Tell me how this is relevant, please. It's a phenomenal essay of facts and some statistics and some facts, but it's not an amicus brief so far. Let's keep going. In this research, even more adults reported other forms of intimate partner violence, IPV, including non-contact sexual violence and psychological aggression. This staggering number conveys the high cost of intimate partner violence to society. Nearly a quarter of female victims, this is number 8, again, still intro, haven't gotten to the meat yet. Nearly a quarter of female victims of intimate partner violence do not report the violence because they fear reprisal. This is echoing the final points of the previous brief that we read yesterday, the Amici brief that we read yesterday. Link is going to be in the description below once this video goes live. Well, once I'm done with it, I suppose I should say. An important 10-year Department of Justice study. By the way, don't forget to like this video, comment below, subscribe to the channel if you haven't already. Reveals that nearly 1/4 of women, 1/4 of women. So again, we're back to statistics. We're spewing more statistics. Very dangerous territory, extremely dangerous territory. Okay. 1/4, so 25% of women abused by an intimate partner do not report their abuse because they are afraid of retaliation. Okay. In Virginia and the US, many abused women are too fearful to report their abuse. That's a terrible fact. Not reporting the abuse makes it more likely that the abuse will continue and escalate because it will remain hidden in the shadows. The abuser can continue to abuse because there have not been any consequences, adverse consequences. Over a 10-year period, almost half of non-fatal domestic violence victimizations were not reported to the police. And again, how do you know that? That is a pure estimate. Absolutely no question about it. How can you know that? Well, how many people did not fall down the stairs this year in the United States? Go ahead. Shout it out in the chat. Like, seriously. How many people did not drop and break their glass this year in the United States as they were drinking their morning coffee? Proving a negative. You can't prove a negative. You can't show how many things did not happen, especially if you throw in statistics. That's even worse. That's even worse. The light of disclosure reduces abuse. I agree. There is a large amount of intimate partner abuse hidden by a shadow of non-disclosure, and much of that is based on the fear of retaliation. Possibly. I wouldn't question that. But this is not what happened in this case. If society wants to reduce intimate partner abuse, a key tool is encouraging and supporting reports of abuse. I mean, Amber spoke out, right? And then she got sued for defamation and she lost because she lied. She's an exception to this rule that you were referring to. This verdict means that juries may ignore abuse unless it is extreme physical violence witnessed by third parties. Whoa, okay, that is a complete sham statement. Hold your horses. That is a complete sham statement. This verdict, this one verdict, means jurors ignore abuse unless it's extremely physically violent towards the other person? What does that have to do with anything? Where is this coming from? This is pure speculation, objection hearsay. Objection, you're making this up in order to make your argument look better, and please keep doing it. Because again, judges are not stupid. They're not going to read that and go, oh my God, I had no idea. They're going to read that and go, objection, where's your basis? Where's your supporting documentation? Where is your supporting facts? Where is your source of law? Don't give me these research studies that you can't trust anybody anymore these days. Nobody is trustworthy. Everybody has an agenda. Everybody pushes an agenda. Everybody tries to accomplish whatever they're trying to accomplish. They're trying to get more money, more support, more people, more marches, more members in their organization, more leadership, more money. Did I mention more money? Yeah, they're also trying to get more money. Oh, and don't forget, they're trying to get more money. So by saying that this verdict is going to have, again, it's a slippery slope argument. They're always doomed to fail from the get-go unless they have a very strong basis, and they almost never do. You're stacking this on top of more speculation that the jurors needed extreme physical violence based on double hearsay that you heard on the news? I mean, you gotta be joking. You have got to be joking. Harper's one-nighter says, if Larry wasn't live, about 1,200 people would be stuck sitting with their families, so hit the like button. Am I helping you escape your family? Like, I'm sorry, I have this very, very important thing I got to do. So, okay, listen. So there's this guy. He calls himself the DUI. You know what? Don't worry about it. I'm just going to be in the next door room. Call me if you need me. The light, or sorry, where was I? I lost my place. Okay, the verdict. In several recent cases, even admissions by an abuser have been insufficient for a finding of abuse in defamation cases, causing doubt in the minds of many women that the legal system can provide them with justice. Dismissing a defamation claim filed by an accused abuser against the victim. So, but that's a good thing that it was dismissed. They filed a defamation suit, and the court dismissed it. But, okay, that's a misnomer, but all right. The verdict in the present case, this is point number 9 in their introduction. The verdict in the present case communicates that retaliation in the form of a defamation action is a powerful weapon against women who report abuse. The verdict punishes Ms. Heard for being a brave liar writing on behalf of the abuse of women. Sorry, I didn't read that correctly. The verdict punishes Ms. Heard for being brave enough to write about the abuse of women. The message is clear. No woman who voices her opinion about abuse is safe from retaliation. This verdict will likely decrease, again, they admit finally that this is pure speculation. This verdict will likely decrease the reporting of intimate partner abuse, objection, hearsay, objection, foundation, with even less reporting of intimate partner abuse, a heinous problem for Virginia and the whole of the United States. Such abuse will worsen. Mark my words. Please. Because this case received such widespread attention, both in traditional and social media, some women have already received the message that they should hide the intimate partner abuse in their life. So we have one case to present to you. Dr. Jessica Taylor, a psychologist in forensic psychology, PhD, so she has a doctorate. She's a doctor, not of medicine, but she's got her doctorate. And author of 2 books on misogyny and abuse, says she has already been contacted by, quote, hundreds of survivors since the Depp verdict, wishing to retract public statements they have made in the press or pulling out of court cases against their abusers. She says the verdict opens the floodgates for future defamation cases. Isn't this fantastic, though? What am I missing? Hundreds of people have come forward and were like, you know what? This never happened. So I don't want to get involved. I do not want to get sued. I fucked up. Can I mulligan? I don't want to get sued and owe this person money for lying about them. Isn't that a good thing, though? Marlena K8 says the only person causing doubt that domestic violence victims are not being treated fairly is Amber Heard. Couldn't agree more. She's a disgrace and has made a mockery out of the judicial system. Exactly. I don't understand. This is fantastic. The fact that hundreds of alleged survivors, we don't know anything about their case. This is just a statistic, a number. They've decided to retract their statements simply means that they realize that they're in the wrong. Most of them. There may be individuals here and there. You can't for the sake of the innocent. Remember, I made this quote, I posted it on Twitter earlier today. It is better to let 9 guilty people go free than to convict 1 innocent person. And unfortunately, the same is going to apply here to a lot of people who do not like to hear that statement. I remember there was even a tweet by an individual. I saw it earlier today again. If it means that innocent men are going to be caught in this net, well, then so be it. I mean, how fucked up is that? That is the most messed up statement I have ever heard in my entire life. That if innocent men are going to get caught in this Me Too net, well, so be it. It's a sacrifice that I am willing to make, she said. That is absolutely despicable and disgusting. That you are willing to throw innocent people under the bus just to achieve your agenda? Because, oh, who are they? They're nobodies to me. Me sitting high and mighty on my throne. Get out of here. All right, we're about to get to the good stuff. For these women, this appeal is an opportunity to erase the message of the verdict that reporters of abuse will be punished. Liars will be punished. Reporters will be freed, hopefully, from the abuse. Like, where are you getting this stuff? They're literally trying to flip the script. It's amazing. It's amazing to see these Me Too people on their back foot. They just don't know how to handle themselves. They're like, well, abuse is abuse is abuse is abuse. Like, how are you guys not seeing this? And the whole world's like, have you seen Amber? A liar? Hello? Anyone? Anyone home? Anyone? Reversal in this case will communicate that retaliation against women who report abuse is not acceptable in Virginia. We want our poster girl back, you guys. Please help us. The statements made by Ms. Heard were speech. Now, we finally get to the summary of the argument. Speech that was protected by the First Amendment to the United States and Virginia constitutions. This is where you should have started, by the way. In writing this abomination of an amicus brief so far, this should have been page 1 or page 2 after your brief introduction. Your 22 pages that I just went through of water that does absolutely nothing for the case, does nothing but, again, this was, I'm telling you, it was pure PR. We'll see which people signed off on this when we get to the end. But this should have been page 2. We should not have spent an hour and 45 minutes to get here. AD says, I'm sorry, but women who have been oppressed by men for millennia, if a few innocent men fall, their privilege could be taken down a few pegs. And that's why they're fighting tooth and nail to maintain their position. All right. This is where it should have started. Should have been page 2. This should have been minute 12 of this video. I'm telling you right now, as an attorney who has read tons of appellate briefs, who has written appellate briefs, I can tell you, you want to get to this as quickly as possible. You want to let the judges know what they need to do and why without wasting their time. The statements made by Ms. Heard were speech protected by the First Amendment to the U.S. and Virginia constitutions. The op-ed was an opinion piece with no direct connection or citation to Mr. Depp. It reflected Ms. Heard's opinion that society in general, and Hollywood in particular, have failed to support women who come forward advocating against abuse. Ms. Heard, like any other American, is entitled to express her opinion on the issues of public concern. And that's the argument. The argument is that it's free speech and it's opinion speech and it's protected and therefore should not have been found liable for her statements. Mr. Depp has alleged that statements by Ms. Heard using the terms abuse and domestic abuse implied a defamatory statement about Mr. Depp, because domestic abuse refers to abuse in the home, right? Domicile, it's from the same term. Dom. It's home. It's the Latin root for home. So when you talk about domestic and she's been married to the guy, just very recently divorced a few months prior, who the heck do you think they're going to be talking about? So the implication of defamatory statement about Mr. Depp, based upon the uncontroverted evidence at trial, and again, there it is, the same word was used in the brief yesterday, uncontroverted evidence. It's a meaningless word. It's a useless word. It's a word that does absolutely nothing. As a judge, I'm skipping over that word, and I'm reading that sentence is, the evidence at trial, based on the evidence at trial, those statements cannot be the basis for a finding of actual malice by any reasonable jury, because they were subjectively true from the perspective of Ms. Heard. Moreover, there was sufficient uncontroverted evidence, or sufficient evidence at trial of actions that satisfied most reasonable definitions of abuse to be considered objectively true. Mr. Depp alleges that Ms. Heard defamed him based on the implications contained in 3 statements from the Washington Post opinion editorial. That's at the complaint. Mr. Depp contends they included implicit innuendo readily apparent to any reader, implying that Mr. Depp engaged in physical and sexual violence against Ms. Heard to restrict the known meaning of her choice of words on abuse to his viewpoint, not hers. If this defamation by implication verdict is allowed to stand, it will have detrimental effects on the ability of commentators to make facially true statements that could be somehow twisted by a public figure into allegations that they had engaged in conduct not specified in their statement? I'm sorry, what? So the implication here that because Johnny has this money and this power, his truth rings louder than Amber's because she doesn't have as much money and power, that is complete horseshit. Where did these people get this stuff? I mean, is this like another one of those ways to blame the patriarchy? Amber Heard lied because the patriarchy has been in power too long, would be another way to phrase this. Like, she had to somehow overcome this male power, so lies were her only option. That is the most bizarre paragraph I think I have read in a very long time. If this defamation by implication, I want to read it again so you all understand the absurdity of their statement. If this defamation by implication verdict is allowed to stand, it will have detrimental effects on the ability of commentators. Which commentators? Are you talking about like future juries and future cases with different facts and different people to make facially, or are you talking about like journalists, which nobody gives a shit about, no offense, but they have a terrible reputation these days. This is going to have a detrimental effect on the ability of commentators to make facially true statements that could somehow be twisted by a public figure into an allegation that they had engaged in conduct not specified in their statement. So just because they're a public figure and they have a medium, but it doesn't matter because the public figure spoke as a person at the trial. Johnny took the stand, and the 7 people that decided the case had a chance to independently evaluate the truth of his statements and the evidence presented in the case. Who cares about external commentators? Nobody cares about those in the context of the appeal. More PR stuff. I mean, so far we are on what, page 24? It's still nothing but PR stuff so far. Let's keep reading. The Amici are concerned about this application of doctrine of defamation by implication. Okay, so this is your concern. The freedom to truthfully speak about abuse in general statements will be restricted, more slippery slope. If you don't do this, it's going to have a profound effect. Terrible argument. Will be restricted if the op-ed's use of the term abuse is held to imply actions that allegedly occurred and were reported more than 2 years before the op-ed was published. The term abuse was not defined in the jury instructions because it's a simple term. You don't need to define it. If you need to define what abuse means, you've been living in a bubble your entire life. And I'm actually kind of jealous of you. But I'm also not jealous of you because when you find out about it, it's going to suck. And hopefully you find out the right way, not the wrong way. Like somebody telling you, not you experiencing it yourself is what I mean. The term abuse was not defined in the jury instructions over the objections of Ms. Heard, as the court refused to give the jury guidance regarding this vague term. I think it's a very specific term. People can judge for themselves what abuse is. You don't need to be told like specifically financial, physical, emotional, sexual. It's very easy. You listen to the evidence and you determine, like, you know what? That doesn't pass the kosher test. They were probably abused. If you need to debate at length, okay, let me explain to you how I was abused, and you need to spend an hour in writing me a dissertation as to why you were abused, you probably weren't. I mean, no offense. It's just the shorter argument is always the correct one. The shorter argument is always the truth. Almost always, I should say. Freedom to truthfully speak about abuse in general. Oh, sorry, I lost my place again. As the court refused to give the instructions. Okay. This vague term that lacks a self-evident definition. Oh, come on. Okay, that's a joke. That has to be a joke. That just has to be a joke. And they're citing the jury interview. Again, wow. Stacked hearsay in a place where it doesn't belong. PR move after PR move. It is also alarming that the verdict was allowed to stand given the utter lack of causation evidence showing that this one op-ed was the source of Depp's financial troubles. No evidence was presented by Mr. Depp that any reader of the op-ed who would have employed him but chose not to had read the article. Okay, so we got to bring in every single person who said no to a job to Johnny and explain that I didn't hire him because of the op-ed. That's ridiculous. It is next to impossible to say that any alleged harm to Mr. Depp was due to some alleged innuendo in the op-ed, which the jury disagrees with you, but okay, as opposed to the dozens of other articles published in the 3 years prior to the op-ed that discussed improper behavior by Mr. Depp. See defendant's exhibits. The necessity of such a connection between any alleged defamation and real injury is crucial to protecting the press and commentators. Oh, get the fuck out of here. Are you joking? Point of view, the Washington Post wants protection for the op-ed. Yeah, literally, Marlena, your comment is so timely. Did they just seriously argue we need to protect journalists and reporters? They did not just say that. They did not just say that. Oh my God. I have no words. I have no words. Like, they're more concerned with protecting the press and commentators. This is the free speech. This is why they're saying, look, okay, she lied. Almost like we admit that, let's say, for the sake of argument. Like we admit she lied. But the Washington Post wasn't sued here. I mean, they got a bad rep because of this. You can't backdoor. We fucked up. We chose the wrong poster face for the Me Too movement, and now we need to mulligan through the court system. That's not what the court system is for. Wow. Absolutely wow. That's a bombshell. This is the bombshell probably in this one. Maybe there's more. We'll see. But at least we got bombshell number one. Let's see if we have more bombshells here. Last, the amici are concerned that a claimant has been permitted to litigate the exact same factual issues in two different forums. But again, double jeopardy doesn't apply. It's two different forums. And obtain different and contradictory findings. Well, one was done by one person, the other was done by a jury in the community. So too bad, so sad that the truth wins. The truth came out and the unbiased jury made a determination. That's a you problem. That's not a we problem. The UK proceeding was Mr. Depp's preferred forum and had a more favorable to Depp burden of proof than Virginia. No, it didn't. They're exactly the same. We covered that earlier. Even though the UK proceeding was against a different defendant, so yeah, he sued a different person, by the way. The exact same facts regarding the abuse in question supported the English court's determination that it was substantially true that Mr. Depp engaged in psychological, verbal, sexual, or physical abuse against Ms. Heard. But we already talked about the fact that they never got a chance to cross-examine her, remember? They never got a chance to cross-examine Ms. Heard in the UK trial. The plaintiff doesn't have a right to do that. And they never sued her directly. They sued the newspaper. Again, that's a you problem, not a process problem. She's trying to get me to play. She just brought me her toy. Zinni. Come here. Even though the UK proceeding, okay, so the UK High Court found that Depp engaged in spousal abuse. Again, this court does not care. The outcome in the United Kingdom cannot be reconciled with the verdict in Virginia. Well, no, duh. You have a different defendant and you had a much different process that allows for cross-examination of the alleged victim, which now we know is the abuser. The message of this Virginia verdict to abusers is that relitigation, defamation, strike-back suits in different courts until a favorable verdict can be obtained is profitable without regard to whether an adverse outcome is obtained in the first case. That is almost never going to happen again. This is going to be extremely rare. Johnny had an opportunity to do that because he had articles in both countries. But most people that are not public figures and don't have articles written about them all over the world are not going to have this issue. So Johnny's case is definitely an isolated incident, not the rule. You're not going to be like, well, you abused me, in this little county in Texas, but I lost here, so I'm going to sue him in France. Like, France has no ties to the case. You know what I mean? That doesn't make any sense. Argument. A, the trial verdict is inconsistent with First Amendment principles and precedent. This is the meat. We finally get to the meat. You had your potatoes and your asparagus with a side of Coca-Cola. Now we get to the steak. Prior to 1964, this is pre-New York Times, defamation actions were guided in Virginia, like most jurisdictions, solely by state common law. After the United States Supreme Court issued its decision in New York Times versus Sullivan, the landmark case on defamation, Virginia courts have been required to factor in the interests of the First Amendment in defamation claims, especially those involving public figures and matters of public concern. This is where actual malice comes from. This lawsuit involves both. Amici are concerned that the threat of frivolous and expensive lawsuits by claimants is significant and increasing, especially in Virginia. What an outlandish claim. What an outlandish claim without any basis. I mean, even their footnote, which I'm kind of grazing over, because Virginia is perceived to have overly favorable defamation law for claimants, many claimants, such as former Congressman Devin Nunes, have attempted to file defamation actions in the Commonwealth's courts that would not likely survive motions in other jurisdictions. Motions for summary judgment, I think, is an unfinished statement there. Okay, so one other example. The reason that Johnny filed in Virginia was because that's where Washington Post is headquartered, and they're were the authors of the op-ed, and that is why it happened in Virginia. But okay, it's an argument. It's an argument to be made. They're making it. People, especially those who have been the victims of abuse, are afraid of speaking out against those who have more power and money. The current case has exacerbated that fear. Again, outlandish statement, objection hearsay, objection foundation, objection speculation. The current case has exacerbated that fear with its precedent. Experts in abuse have already seen a real-world chilling effect. Are you talking about that one person that you quoted earlier? Again, objection, hearsay, speculation, foundation, and unintelligible. Experts in abuse have already seen a real-world chilling effect on women coming forward with abuse claims. Even before the verdict in this case, First Amendment advocates expressed that these suits, frivolous or not, take their financial and emotional toll on the defendants, even if they ultimately win, especially when those defendants aren't New York Times. In reality, it is a suit or threat used to silence and harass critics by forcing them to spend money to defend a baseless lawsuit, something that is intended to intimidate, not win. Someone faced with a slap action, and slap lawsuits, by the way, are basically what they're referring to are frivolous lawsuits that are filed by individuals who have a lot more money and power. So in order to get their way, Donald Trump is a huge fan of slap lawsuits. They'll just file them. They'll just file them just to make sure that you get silenced because you don't have the money, the power, and the ability to fight these lawsuits, even though they're completely pointless and frivolous. It's an acronym. SLAPP. You can look it up. I just don't remember off the top of my head. But someone facing with slap action generally ends up agreeing to retract their statements for the reasons I just stated, apologize, or refrain from further comment on the matter in order to stay out of court. And slap lawsuits are a real thing. Don't be mistaken. It's just Johnny's was not, as we can obviously tell, because he won. It's not about his money and power. It was about restoring his reputation based on the statements of a liar. Big difference. Okay. So that case right there discusses the effect of slap lawsuits and abuse cases, such as silencing speech through the inconvenience and cost of litigation, producing a chilling effect by, they really love this phrase, chilling effect. They will have a chilling effect. They're arguing policy. Like their primary vehicle that is driving both of these briefs, these amicus briefs, are chilling effect. Chilling effect is not a good argument. Chilling effect is something that you say to your boyfriend when you're cuddled on the couch and you say, look, it's really, really cold. Will you hold me? That's called the chilling effect, right? I'm cold. It's an excuse for him to hold you. Because women, they like to be held. That's fine. We love to hold you. There's no problem there. But that's the chilling effect. This is not a good argument. The chilling effect, the chilling phenomenon, the chilling effect that this will have, judges don't care. Give me the legal argument. I have yet to see a legal argument here. All I'm seeing is policy and more ploy and play on emotion. producing a chilling effect by preventing others from making similar statements in the future for fear of facing a lawsuit. For example, wealthy and influential plaintiffs can punish their less well-resourced targets with time-consuming and costly litigation, thereby deterring similar speech in the future. And that is just another article. It's not even a case. A New York decision accurately assessed the problem when it dismissed a defamation claim by an accused abuser, holding that the lower court's decision allowing the claim to proceed has the effect of emboldening sexual assaulters who seek to weaponize the legal system in order to silence their victims. No question, it will happen from time to time. I'm not saying it will never happen, but these are isolated incidents and they have absolutely nothing to do with the case. This is not what happened in this particular case. You're talking about the possible other cases that have no bearing on what happened here. As the Segali court, okay, I remember that name. They used that in the other brief as well. So that's their main authority. That's their main authority. Sexual assaults remain vastly underreported, primarily due to victims' fear of retaliation. It does not escape us that defamation suits like the instant one may constitute a form of retaliation against those with the courage to speak out. Most victims cannot afford years of litigation, nor do they wish to have their personal information disclosed through invasive discovery or to relive their personal trauma through litigation, including depositions, filings, and testimony in court. They do not wish to endure continued unwanted interaction with the person alleged to have assaulted them through the litigation process. And again, this is a very powerful statement, and this is a very true statement. But just because other cases may suffer through that does not mean you need to undo the jury's rightful verdict in this case after they heard all the evidence and made a decision. So it's a great way to explain that these things could potentially happen, but just because this case is going to have a chilling effect, so to speak, is not reason enough to undo a rightful verdict where justice was done. It is lobbyist language. It's lawyer language. It's judge language. Absolutely splodge. Trial court, this is part one of the argument, the first argument. The trial court should have ruled that Ms. Heard's op-ed was protected speech. Ms. Heard's op-ed was protected opinion. This is their first argument under this umbrella. The Amici believe that this court should hold as a matter of law that the opinion editorial drafted by Ms. Heard was opinion written to address the problem of retaliation in Hollywood when women speak about men who abuse their power to harass and assault women. All right, we have our first actual legal claim. The point of the op-ed was to illustrate this problem and to encourage advocacy for political and social reform. Ms. Heard wrote about having suffered abuse at an early age, including being harassed and sexually assaulted by the time she was of college age, long before she met Depp. Generally, a statement of opinion relating to matters of public concern, which does not contain a provably false factual connotation, will receive full constitutional protection and not be considered defamatory. So here they're arguing that the Judge Escarati's decision to not, as a matter of law, argue that this is a judge that this is a matter of opinion and not subject to scrutiny by a jury of one's peers, she got it wrong. This is basically what they're trying to say, I think, is where they're headed. So generally, a statement of opinion relating to matters of public concern, which does not contain a provably false factual connotation, will receive full constitutional protections and not be considered defamatory, right? Pure expressions of opinion, not amounting to fighting words, cannot form the basis of an action for defamation, which is half true. They need to include more language in this statement. But yes, that is partly a true statement. The First Amendment to the United States Constitution, Articles 1, paragraph 12 of the Constitution of Virginia, protect the rights of the people to teach, preach, write, speak, any such opinion, however ill-founded, without inhibition by actions for libel and slander. One of our most important Virginia founding fathers explained, error of opinion may be tolerated where reason is left free to combat it. In evaluating defamation, courts must consider the general tenor of the publication, not just the specific words out of context. Generally, statements that are relative in nature and depend largely upon the speaker's viewpoint are expressions of opinion. Whether a statement is opinion or fact requires the court to evaluate whether a statement can be proven to have a false connotation. Whether allegedly defamatory statement is one of fact or opinion is a matter of law for courts to determine, not juries. That is true. And the court determined that it was not opinion, and that's why it let the jury decide. So far, so good. In the present case, the trial court erred in its analysis and evaluation of the nature of these alleged implicit statements. This is their argument. Although every fair inference must be drawn in favor of plaintiff appellee in determining whether the words and statements complained of in this case are reasonably capable of the meaning ascribed to them by the alleged innuendo, the meaning of the alleged defamatory language cannot, by innuendo, be extended beyond its ordinary and common acceptation. The province of the innuendo is to show how the words used are defamatory and how they relate to the plaintiff, but it cannot introduce new matter nor extend the meaning of the word used or to make that certain, which is in fact uncertain. And this is where they're going to probably launch into the argument that Johnny has argued by implication, like all this allegations of abuse and all of that, all of those should fail because they were simply Amber Heard's opinion. But truth is a complete defense to defamation. Don't forget, truth is a complete defense, but not lies. If you lie about somebody, thereby ruining their career, that is not protected speech. Marlena K8 says it wasn't an opinion when she was speaking out about her ex-husband directly, and that's exactly the counter argument right there. Amber Heard made an indirect accusation. It was not commentary. This is the counter. You're exactly right. You're exactly right. All right. Any matter that can be considered in evaluating the statement must be within the publication itself or within the public's knowledge in the immediate past. Innuendo established at the pleading stage when facts relevant to innuendo were still in the news and statements specifically referred to those facts, looking within the full statement for the defamatory meaning. Now, here is where they tie it to the facts. Ms. Heard's opinion editorial focused on the treatment that women who spoke out regarding abuse received from the public. The op-ed, taken on its face and in the proper context, was not an attack on Mr. Depp, but, and the jury thought different, but an indictment of society in general and Hollywood in particular. Again, the jury disagreed. For not supporting women who spoke up about a wide range of abuses, because the statements by Ms. Heard in that op-ed did not contain a provably false actual connotation and were not fighting words, but were pure expressions of opinion. They should not have been considered by the trial court or this court as defamatory. Were it to be held otherwise, this precedent would have profound, I'm surprised they didn't use the word chilling here, profound effects this time. Profound effects on the amici and their ability to opine on the prominent issues of the day. Again, protecting journalists. They're protecting people who write about this stuff. This is unbelievable. This is absolutely unbelievable. Okay. Protecting journalists, not victims. That's the theme of this brief. Protecting journalists, not victims. To affirm the verdict in this case is to chill. Oh, there it is. I spoke too soon. To chill the First Amendment right to express one's opinion and encourage frivolous defamation claims based upon what a claimant can imply from what is spoken rather than the actual words of the speaker. Taken in this context, the two statements contained in the op-ed that were actually written by Ms. Heard, which do not mention Mr. Depp, are merely a summary of her opinion and view regarding her life experiences. Bottom line. This is a phenomenal way of making a bogus argument, basically. Fascinating. Okay, let's keep going. Part 2 of this argument. Abuse in the op-ed was subjective perspective. Was a subjective perspective. So basically, Amber's own personal subjective perspective, not objective. Ms. Heard's reference to abuse and domestic abuse, again, they're trying to backdoor now, again, are subjective opinions of her perspective, not a verifiable fact that could be defamatory. So they just shifted gears. They went from First Amendment protection to, well, this was subjective. This is just the way she thought the jury got it wrong. So we went from good argument to back to bad argument. And when I say good, I don't mean that it's going to stand muster, because I don't think it is. Arguing that it's an opinion without any supportive case law to support the fact, because this is what lawyers do. We take our fact pattern and we say, look, Your Honor, to the Court of Appeals, our fact pattern is very much like that fact pattern over there. They're very, very similar. This is what the lawyers said in that case. This is how the judge adjudicated that case, and you should do the same thing here. They haven't done this yet. They haven't done this at all. Staggering. Demonstrating that the op-ed contained only opinion. We'll see if that will change or not. Demonstrating that the op-ed contained only opinion, Ms. Heard only used the vague and undefined terms abuse and domestic abuse in the op-ed in the two contested non-headline statements, and in neither instance mentioned Mr. Depp, except by implication, as we know. They admitted to it. The statements represented her viewpoint regarding her experiences. In both cases, the op-ed contained Ms. Heard's true opinion as an advocate speaking out against domestic abuse. But she already testified. We have a record of her saying, yes, it was him, and this is what he did. So all of these arguments are falling on deaf ears at this point of the judges. The term abuse, as used by Ms. Heard, is subjective. It is an opinion in the eye of the person who has been subjected to a wide variety of conduct, and not subject to a clear true-false analysis. The statement relative in nature and depending largely on the speaker's view is an expression of opinion. Comes from a case called Highland. During the trial, there was oh God, there's that word again. I'm going to just ignore it because it's a meaningless word that has no business in a brief. During the trial, there was evidence regarding actions by Mr. Depp that constituted abuse from the perspective of any woman. Again, generalizing. Did a college kid write this brief? Again, these are not legal arguments. These are like generalizing arguments of emotion. For example, a video showed Mr. Depp storming through the couple's kitchen in a drunken rage, swearing at Ms. Heard. A lot of adjectives, no substance. In that uncontested video, okay, here I will forgive it because the video is what it is. You can't change a video unless you doctor it. Mr. Depp expressed severe anger at Ms. Heard for an alleged transgression by, in Mr. Depp's own words, assaulting kitchen cabinets with kicking and slamming, and then confronts her when he sees that she had videotaped the incident. Okay, so he attacks stuff. That's not abuse. He's abusing the kitchen cabinet. He threatened Ms. Heard with, "I'll show you crazy," picked up her phone and slammed it down, ending the taping. Other uncontested examples of abuse proven during the trial included, and now they just go through the same list. This is literally the exact same list that is irrelevant, has no bearing on the case, and we're back into territory of why is this in here? I'm literally going to skip over it because it had absolutely no bearing on the judge's decision. That's what a judge would do. They're just going to skip over that. They're trying to highlight, they're trying to point out as much as they can. It may have been written by a paralegal, retired Nanisys. This was probably written by a paralegal. I couldn't disagree based on, so far as to what I'm reading. This had to be approved by the lawyers. They signed their names to it. They can't just, she brought the other toy. She's like, well, you're not going to be playing with me with this toy. You're not going to be playing with me with this toy. So let me bring this other toy. Maybe you'll play with me with this one. She's a very, very intelligent cat. Come here, Zinni. She's like the smartest cat I have ever met. Come here. We're going to say hello to the chat. Hi, chat. Say hi to the chat, Zinni. Camera's up there. Can you see it? She's like falling asleep. Hi, Zinni. You see that? Say hi, chat. Hi, chat. All right. Back to the brief. She's so cute. Depp was asked about this interaction, admitted that he said those words. In a follow-up questioning, Mr. Depp asserted it was not an intentional headbutt. Although Mr. Depp claims that he did not intentionally headbutt Ms. Heard, under Virginia law, Mr. Depp's testimony was an admission by Mr. Depp that he abused Ms. Heard. Again, trying to backdoor, jury got it wrong, listen to us, judges. His statement at trial that the headbutt was not intentional, reiterated that he did headbutt Ms. Heard. I mean, I swear, this is literally, it's like I'm reading, no, he didn't. Yes, he did. So you guys need to listen to us. Stop listening to the thing that is going on over there. Listen to what we have to say, which is not an appellate argument. This is literally like kindergarten stuff being brought into an appellate brief. Unbelievable. His statement at trial that the headbutt was not intentional reiterated that, yes, he did. The definition of family abuse is found here. Does not require intent or willfulness. It doesn't matter if it was intentional to be abuse. Fantastic. It says absolutely nothing. An analogous situation was at issue in Fairfax versus CBS Broadcasting Incorporated, in which Virginia's then lieutenant governor sued a television network based upon its interviews with women who alleged that he had raped them many years before they announced their allegations. Mr. Fairfax also complained about sympathetic comments by the co-host of CBS's morning show after the interviews were aired. The federal court granted a motion to dismiss the defamation claims in that case, explaining that the relied upon commentary, when read in the context, does not ascribe to any particular view of the underlying events, but rather on how persons who believe they are victims of sexual abuse are affected. How is that in any way, shape, or form relevant to the case at bar? Still don't see it, but okay. The exact same words could be said of the op-ed. They could. Sure they could. But should they? That's the question, and the answer, obviously, is no. Judges normally don't consider trial testimony out of context, Dwayne. That's a great question. They look at everything in context and try to make the best decision. So they could be said of the op-ed published by Ms. Heard. The crux of the op-ed was not to rehash the allegations that Ms. Heard had previously made regarding Ms. Ms. Depp's conduct. We got another typo. The crux of the op-ed was not to rehash the allegations that Ms. Heard had previously made regarding Ms. Depp, Mr. Depp's conduct, but rather to express Ms. Heard's experience after she made those allegations. At no time in the op-ed text did Ms. Heard talk about the specifics of any alleged abuse by Mr. Depp, even without mentioning his name, but rather again, they're trying to relitigate the case, backdooring it. That's not how appeals are done. But rather she talked about the effect of coming forth as an advocate for women who had been exposed to abuse. In her op-ed, Ms. Heard used the term abuse to summarize her experience. All she's doing, you guys, she's just summarizing experiences. And this must be what comes out when borderline personality disorders write a legal brief. I wouldn't go that far, beats Kilbean, but lots of words, no substance. Yeah, it's definitely that. Lots of words, no substance. I will agree there. Okay, bless you. Looking at this, anytime a person would publish a comment about a topic, slippery slope, not a specific incident regarding that topic, such as discrimination or suppression, numerous claimants may mistake or interpret the mention of that overall topic for a specific allegation and bring a lawsuit. If this type of defamation is permitted to state a valid claim in Virginia courts, Virginia newspapers, television stations, commentators, and citizens would be severely limited in their ability to speak about important matters facing Virginians on a wide range of issues, not just abuse, such as those discussed in Ms. Heard's op-ed, but also racial discrimination, issues involving the suppression of political speech, and any other issues involving public debate. At the trial and subsequent comments of the jury illustrate, the term abuse is one that is subjective and is open to interpretation depending upon one's vantage point. Right. It's based on life experiences, and sure, but everybody understands the idea of what abuse means. We had adults on the jury. The Amicus maintained that as a matter of law, the term abuse in the op-ed is not reasonably capable of the defamatory meaning that Mr. Depp ascribed to it, but rather Ms. Heard's subjective opinion. And that's why the verdict basically should be overturned. Very, very unique stuff. Not powerful, not strong. The alleged abuse defamation was not based upon facts that were verifiable. This is under first argument, point number 3. In reviewing the publication, to determine whether it is defamatory, a reviewing court must consider the entire published statement, not just an excerpt thereof out of context. The Federal District Court in Fairfax versus CBS case achieved the correct balance by reviewing the entire publication and the alleged defamatory passages in context rather than focusing on certain passages, and is consistent with Virginia precedent. A recent decision from, Western District of Kentucky, hello, regarding another highly publicized incident is instructive. Sandman versus New York Times. In that case, a student wearing a Make America Great Again, a MAGA hat, Sandman, stood in front of an older Native American man, Phillips, while the latter attempted to go to the Lincoln Memorial to engage in a tribal ritual. You all remember this incident, by the way. That famous meme where he's pointing at the dude, and it went viral. After the incident, Phillips was quoted by a newspaper as stating that Sandman just blocked my way and wouldn't allow me to retreat. The plaintiff initially filed cases against several news organizations on several grounds, but the court dismissed all other claims, narrowing the issues to whether the newspaper's publication of this discrete quote was defamatory. In analyzing this question, the Kentucky federal court applied Kentucky state law on defamation, which is similar to that of Virginia, holding this statement as not defamatory. The court concluded that Philip's statement that Salmon blocked him and wouldn't allow him to retreat were objectively unverifiable and thus unactionable opinions. Don't forget, this is one fraction of one moment in time that happened over the course of several minutes, whereas abuse, or the alleged abuse, abuse by Ms. Heard, alleged abuse by Mr. Depp, has happened over the course of months, if not years. So it's a very, very different fact pattern. I see they're trying to kind of reason it through that case, but that case is literally an isolated incident, a moment in time. A moment in time is vastly different from months, if not years of experience. As a former paralegal, Angel Parent Perez says, I can honestly say that no well-educated and seasoned paralegal would have written any crap like this. She's like, don't you be hating on my paralegals. Paralegals write good stuff. I respect that. I respect that, Angel. Thank you for speaking out. Philip's statements blocked him and wouldn't allow him to retreat were objectively unverifiable and thus unactionable opinions. Instead, a reasonable reader would understand that Phillips was simply conveying his view of the situation. The court further explained that generally, blocking is an imprecise term capable of different meanings that lacks a plausible method of verification. That court was absolutely right, but it has absolutely no bearing on this case because you're literally talking about one little moment in time compared to years of evidence that the jury had to listen through. Big, big, big difference. Here, you don't need analysis of seconds of conduct by a judge, by a jury. A judge can adjudicate that. Not so much with the Johnny Depp Amber Heard trial. That's why it was sent to the jury. That's why a jury decided that case. Here, as in Sandman, the word abuse is an imprecise term capable of different meaning that lacks a plausible method of verification. Statements containing terms such as swarming, taunting, disrespect, aggressive, and others protected by the First Amendment, they are not susceptible of being proven true or false, citing Milkovich. In the present, that's another case that they really like. In the present case, Depp's counsel focused on just a few words and then merged those comments out of context with statements and acts that occurred more than 2 years before. I'm not seeing anything, you guys. So far, I'm not seeing anything. But let's keep going. Let's see if we can find a scintilla of argument in this amicus brief. Statements in the op-ed cannot be the basis for a finding of actual malice. In order to find a person liable for defamation when the matter at issue, as here, involves a public figure. So now they're attacking the actual malice standard. They're probably, I imagine, going to be saying that it doesn't rise to the standard of actual malice, even though the jury, again, decided that it did. This is New York Times, which requires the plaintiff to show that the the defendant knew the publication to be false, or there was evidence of reckless disregard for the truth. While there may be a debate as to whether the word abuse is a verifiable fact or an opinion, in the present case, there was unrefuted evidence. Again, unrefuted. I hate these words. There was evidence that Mr. Depp engaged in actions that could be considered abusive to Ms. Heard under any reasonable definition of the term. Objection hearsay. Again. Thus, as a matter of law, the trial court should have held, and this court must hold, that Ms. Heard's statements about abuse were legitimate subjective articulation of her perspective and cannot be considered to constitute actual malice in any defamation analysis. Again, the jury begs to differ. The judge allowed it to proceed. Okay. Based upon the objective, uncontested evidence of the actions described above, that can only be considered abusive. There it is again, this language. The alleged implication of Ms. Heard's statements that Mr. Depp had engaged in abuse and domestic abuse were reasonable and could not be found by a reasonable jury as uttered in actual malice under Sullivan and its progeny. This is New York Times. As a result, these defamation claims should have been and now must be dismissed. Number 3, no defamatory facts could reasonably be implied in the op-ed written by Ms. Heard. In considering a claim for defamation by implication, the question is whether the article is reasonably capable of the defamatory meaning to which the claimant ascribes to it and is a legal issue for resolution by the court in its gatekeeping function prior to being submitted to the jury. Comes from a case by the name of Webb, where the statements of fact are literally true, but by an implication arising from them are alleged to be false. The alleged implication must be reasonably drawn from the words actually used. To be defamatory, the statement must be based upon the reasonably implied interpretation of the statement, holding that no defamation was there, where an alleged defamatory statement cannot reasonably be understood as stating an actual fact about plaintiff's conduct. So defamation must be explicit in that way, is what they're saying. Implicit defamation doesn't work. But when you're writing an op-ed, and this is going to be the counter argument in Johnny's brief, a response brief, I imagine, is that there was only one inference. It wasn't like a slew of inferences and they had to jump to some conclusions. If there was only one inference that the op-ed is talking about a certain individual and not like another individual, well, then it's easy and it doesn't require further analysis. And that's why the judge let the jury decide. In the present case, the statements made by Ms. Heard were, on their face, true. In the present case, the statements made by Ms. Heard on their face was true, that I'm a public figure representing domestic abuse and I spoke out against sexual violence, faced our culture's wrath. First, in 2016, Ms. Heard did become a public figure representing domestic abuse who eventually spoke out on behalf of ACLU. Just because she's the poster child, though, doesn't mean that it's true, though. That's the problem. What? Are they seriously trying to say that, well, because she's a poster child, we can believe her? These organizations support, I mean, again, liars and moles leak into organizations all the time. All the time. It's not a new concept. It's known as having a spy, a mole amongst you. They're not there to help you. They're there to help themselves and maybe relay information to a competing agency or government or whatever, or just to better themselves. So just because you have a mole or a spy amongst you does not necessarily mean that we should just automatically go on and believe, well, look, she was just a spokesperson for ACLU. Whoop-de-fucking-do. That doesn't mean anything. At the time it did, 6 years ago, but trying to turn back the clock does not accomplish any goals for the appellate process or in the public's eye. Abuse and eventually speaking out on behalf of the ACLU and sexual abuse and domestic violence. Okay. For this advocacy, she was subjected to severely adverse responses. Well, duh. Second, Ms. Heard has seen that institutions provide protection to men who have been accused of abuse. Third, as an individual and later an ACLU rep, she spoke up about sexual violence and has received negative responses and further believed that this should change. Again, this is literally, they're just changing the words, changing the language, quoting the op-ed. There was no mention of Ms. Heard's marriage to Mr. Depp or any mention of him in the op-ed. So this is their backdoor. They're trying to say, look, they didn't mention him directly. This is what they tried during the trial and they failed, and they're trying again here, the Amici, in their brief. They're trying to say, look, he wasn't mentioned by name, even though, yes, all of that happened and she already admitted to it and it's in the record, but shouldn't have been given to the jury in the first place. Terrible argument, but it's their argument. Nonetheless, Mr. Depp alleges that each of these statements were defamatory by implication. Depp asserts that these three statements are of and concerning Mr. Depp, and as he is Ms. Heard's former husband, and she publicly and falsely accused him of domestic abuse in May 2016. Moreover, Ms. Heard intended to refer to Mr. Depp in these statements, and those who know Mr. Depp or who read the sexual violence op-ed understood these statements to be about Mr. Depp. Depp further claimed that these statements, which imply that Ms. Heard was the victim of domestic violence at the hands of Mr. Depp, are false. There was no temporal relationship between the allegations of abuse by Ms. Heard with the resulting publicity and the op-ed article. The trial court allowed these claims to move forward despite the fact that the information that Mr. Depp used to establish the implications were made when Ms. Heard obtained a TRO over 2 years prior. So again, they're trying to show that the lawyers should not have argued about the TRO and like opening and closing, even though it didn't come into evidence, except that one moment where I think the deposition by Ms. Heard is played to the jury. There was no objection made by opposing counsel, and now they're trying to backdoor any objections, and that's going to fail because objections must be made on the record, otherwise they're not preserved. These objections never happened, therefore they're not preserved, therefore the argument fails. And Amber was never married before, so who else would it be about? Exactly. Relitigating the trial, Jen. Exactly. This is literally what I'm saying. They're trying to have a second trial without a jury. The trial court allowed this to go forward. Okay. Moreover, and by the way, it's not the trial that allowed, it's the fact that there was no objection in the middle of trial to this being mentioned. Moreover, there is no evidence presented that the Washington Post, the forum for the op-ed, had ever published any of the information relied upon to flesh out the alleged defamation. There was no evidence that the Washington Post had previously published articles about these allegations, which were protected in 2016 and beyond the statute of limitations, anytime in near proximity to the op-ed. There can be no implication that the readers of the op-ed would have had a reasonable basis to assume that these facially true and unrelated comments were about Mr. Depp. Are you kidding me? Oh, come on. Yes, Trixie, this is all part of her appeal. This is the amicus briefs that have been filed. Now, in the beginning, it did not state whether Mr. Depp agreed to these, stipulated to these this brief being filed. I know they objected to that one. So actually, there's a rule violation in this brief that I just caught. I'm not going to publicly state it on Twitter because then they may have a chance to fix it, but it may already be too late anyway. But I believe the rule requires you, as we read it the other day, 53A .20 or whatever it was, the rule requires the lawyers that file the amicus brief to state whether the party objected or consented. And in the brief we read yesterday, Amber Heard consented, Johnny Depp objected, as we expected. I imagine the same thing happened here, but they need to state it in the brief. Maybe it's at the end, I don't know, but it certainly is not in the beginning as we read it together. So that's a huge point. That's a mess up. They screwed up so far. It may be, we're not done yet. So at least that's a huge point. That's a violation, a blatant violation of the rule if they did not include it. Mr. Depp stretches the meaning of the words used by Ms. Heard beyond their normal meaning and reasonable construction in the op-ed. The statement that Mobile Oil president set up his son in business could not be extended to interpret that the president had set up an entire business relationship to benefit his son, is an example. So implication. All right, that was argument number one. Argument number two. And let's see. We don't have all that much left, I don't think. They have four arguments, but we're almost done. We're actually almost done. I know it may be exhausting in some of you, I imagine, but we're actually almost done. We're coming to the final stretch. the final stretch, excuse me. So republication of the headline written by a Washington Post staffer cannot be the basis for liability. I can tell you right now that this is not going to have a whole lot. Although the Supreme Court of Virginia has not formally addressed the issue, the amici believe that the Fourth Circuit is correct, that Virginia would follow the great majority of states that now follow the single publication rule. Under the single publication rule, a statement on a website is not republished unless the statement itself is substantively altered or added to, or the website is directed to a new audience, which is, by the way, is exactly what happened with Amber and her retweet, because it is a statement on a website republished because it is substantively altered because she added her own text to it. And the website is directed to a new audience, namely her followers. So literally right there, that argument fails on its face. A mere hyperlink without more cannot constitute republication. But I don't think this is related to Twitter. I could be wrong. We'll see. It is uncontested that a Washington Post staffer wrote the headline, Amber Heard, I spoke up against sexual violence and faced her culture's wrath. That has to change. And that Ms. Heard did not participate in the creation of that headline. It is uncontroverted that Ms. Heard sent out a tweet, a message on a social platform, Twitter, formatting an online copy of her article to her followers on that platform without adopting or addressing the heading. Nonetheless, the jury in its verdict found not only that she was liable for the headline, but that the republication was with actual malice. And now we already know why. Because she wanted two things. She wanted a boost of sales for the Aquaman movie that was premiering in literally 2 days. And number two, she was seeking to ride the coattails on a lie against an A-lister. And what better way to get your name out there than to walk over the bones and ashes of an A-lister that you crushed and created lies about. In the present case, the facts are not sufficient to establish that Ms. Heard's lone tweet was a republication for which she can be liable in defamation, as it did not alter the headline, did not add to the headline, nor did it discuss the headline in any manner. Further, no reasonable jury could have found, even though they did, that Ms. Heard's retweet of the article was done with actual malice, which they also did, to defame Mr. Depp. If this tweet is considered republication under Virginia law, then numerous other links on social media platforms to publications would create liability for millions of Virginians. But that is true, and it does. And that's a true statement. It does create liability for millions of not just Virginians, but citizens of this great nation. Is if somebody, right, this is why you have to be careful what you write and what you republish and what you publish. Because if what you republish is not true, you may suffer consequences and people will sue your ass. I mean, that's a fact of life. Welcome to reality. Argument number 3. Mr. Depp provided no causal connection between the op-ed and any alleged injury. Damages are not normally awarded when they are uncertain, contingent, or speculative. Likewise, causation must be established in order to support a defamation verdict. In Virginia, a statement must contain the requisite defamatory sting to be actionable. Given that Mr. Depp was awarded $10 million in compensatory damages by the jury, the process requires some basis for such an award. If large claims for defamation can be awarded in the absence of evidence of causation of harm, again, in protection of media organizations across the Commonwealth have good reason to shut down their editorial and news departments in fear of such an enormous potential verdict. Good. Then shut yourself down. Like, are you serious? This is ridiculous. Like, media stations are going to suffer if you don't do this, judges, is not a good argument. Wow. I can't believe it. This is the third time they mentioned it. Mr. Depp's counsel presented a distorted view of whether the op-ed actually caused harm to Mr. Depp. There's no evidence that any Hollywood or other movie executive relied upon Ms. Heard's vague references to her being ostracized for becoming a public figure representing domestic abuse to deny Mr. Depp any role. No evidence that Disney had a copy of the op-ed or considered it. On the contrary, there were numerous prior publications, which are all hearsay, not admitted into evidence, demonstrating the risks and dangers of employing Mr. Depp. In fact, although Mr. Depp asserted that most of his damages from the op-ed were the result of Disney refusing to hire him for Pirates 6, a movie that is yet to be made, Disney's corporate designee testified that Disney had found no copies of the op-ed or emails discussing the op-ed in its files. Even though everyone probably talked about it, I imagine that was probably the hot topic of the day. Despite having copies and discussions of many other negative articles about Mr. Depp and a copy of the UK judgment in its files. By the way, don't forget to like this video, comment below, subscribe to the channel if you haven't already. There can be little doubt that Mr. Depp's reputation and actions were well known long before the publication of the op-ed. It is also alarming that the verdict was allowed to stand given the utter lack of causation evidence showing that this one op-ed was the source of Depp's financial troubles, especially given Depp's previous unsuccessful defamation suit regarding statements from the English newspaper The Sun in another court. And again, none of this really matters at the end of the day because the jury is in the best position to determine damages. You can ask for the moon, and the jury can give you $1. Jurors are people; they get to decide what to award. You can ask for whatever you want. Like, for instance, the Hans Niemann versus Magnus Carlsen defamation lawsuit for $100 million. Is he going to get it? Probably not. Is he going to get something? Probably, especially if he was defamed. Accuse him of cheating. That's a big fucking thing, So jurors are in the best position because they're the ones who sat there and listened to all the evidence. We, the appellate judges who are reading this amicus brief, we're not in the courtroom and we have to defer to what they decided unless you can show us a legal argument. So far, these are very, very, very weak. The strongest claim was the First Amendment claim, and even that seems to fail, as you all saw, as we read through together. Mr. Depp's counsel in that case claimed that the wife beater assertion, and they love that phrase, by the way, and it has lost all meaning. It has lost all meaning because of this trial. It is actually now scoffed when it's uttered in public, if you noticed. Mr. Depp's counsel in that case claimed that the wife beater assertion in the Sun article was a reputation-destroying, career-ending allegation. How could anything said by innuendo by Ms. Heard in a December 18, 2019 op-ed have damaged Mr. Depp if his reputation had allegedly already been destroyed and his career ended in April 2018 when the Sun article was published? It is understandable that the jury was misled into believing that there was such a connection between changes in Mr. Depp's career trajectory and Ms. Heard's previous statements. Long before the publication of the op-ed, given that the jury was not permitted to see evidence of other publications which were strongly critical of Mr. Depp, especially the Sun article and subsequent high court trial. For 6 weeks, the jury was exposed only to the alleged statements by Ms. Heard from April 2016 up through the op-ed's publication in December 2018 without the context of other critical publications regarding Mr. Depp, because that's what the lawsuit was about. Oh boy. Final argument. The trial court should have dismissed this action based on comity. In addition to the First Amendment concerns regarding this verdict, there is reason for the amici to be concerned that the trial court gave short shrift to the UK High Court's decision, finding that it was substantially true that Mr. Depp engaged in spousal abuse against Ms. Heard, causing her to suffer significant injury and on occasion leading her to fear for her life. The UK court further found the abuse to have sexual dimensions and sorry, my brain is tired. Prodigious amounts of property damage caused during jealous sexual accusations in non-contact sexual violence against Ms. Heard, which created a probable balance of sexual assault. The Fairfax trial court held that the libel laws of Virginia are starkly different than those of England. What a surprise. The Declaration of Independence and the First Amendment of the U.S. Constitution represent major departures from the English common law with respect to freedom of speech and freedom of the press. That is why she allowed this case to move forward. This is illogical. It's illogical. UK should have just succeeded, is what they're saying. Screw the United States legal system. Let's focus on what happened in the UK. Not a good argument, especially to US judges. This is illogical, given that any First Amendment protections implicated by the alleged defamation in the op-ed would have protected Heard's speech, not Depp's interests. The considerations regarding comity in the UK judgment supported its application in the present case. So basically, you should not have two, you can't have two decisions. This is amazing. This is incredible. Oh, man. In the current age, when a fact is published in one forum, it is often picked up and republished in various other media. A claimant should not be able to sue one publisher in one jurisdiction, lose, and then sue another publisher regarding the same exact facts in another jurisdiction. But that never happened, hoping to get a better result. He sued the Sun, then he sued the person. So that fails. While there may be exceptions to this rule, such as jurisdictions in which the rule of law is not given the same respect as that of our Commonwealth, here Mr. Depp got a second bite at the apple, which is not exactly true, but I see why they're trying to portray it, on the very same facts upon which he had already lost the case in the UK. What is more galling is that Mr. Depp was the one who filed the UK action, and he was the one who chose to litigate that case first, relying on the more favorable standard of review. Again, it's the same standard. I don't know where they're getting that. When he lost in the UK, that decision should have shut down any further actions based upon the same facts. Comity is basically double jeopardy, if y'all haven't caught on yet. It's the civil double jeopardy standard. Okay, conclusion. The trial in this case was not about any defamatory statements made by Ms. Heard within her op-ed itself, but rather was a vendetta for all of the publicity surrounding the allegations of abuse by Mr. Depp from the date that Ms. Heard sought and obtained restraining order in May 2016 up to December 18th, 2018. A defamation lawsuit based upon this op-ed was not the legitimate vehicle for remedying Mr. Depp's dissatisfaction with how his career has developed, how his marriage ended, and the negative publicity he has received, much of it warranted by his own actions, as evidence excluded would have shown. He cannot seek retribution for the allegations that were made in the California courts regarding his alleged physical abuse of Ms. Heard, their divorce, and subsequent publicity from various venues, including The Sun. Defamation by implication is a limited doctrine that does not allow a litigant to rehash dissatisfaction with his public coverage from years ago from all sources. The doctrine further does not allow the claimant to twist the meaning of the words in a publication that is alleged to be defamatory. When evidence establishes that the defendant has a subjective basis, considering their vantage point for the statements they have made, actual malice cannot reasonably be found. The damage that will be done if the verdict is upheld to First Amendment jurisprudence, the ability of Virginians to express their opinions, and the ability of women to report domestic violence for fear of retribution and an expensive lawsuit would be no less than catastrophic. For these reasons, the Amici respectfully request this honorable court reverse the judgment against Ms. Heard with instruction to dismiss all of Mr. Depp's claims. Respectfully submitted. There are the lawyers again. I hereby certify it was true and sent here. 50 pages, so many words. They screwed up. They screwed up. They forgot to include who agreed and who disagreed. Oopsies. We're supposed to do that. They didn't do that. And there are no names. Remember I said that there's going to be an Exhibit A with all the names? It's not here. There is no Exhibit A. So when they mentioned in the beginning that there's going to be an Exhibit A, there is no Exhibit A. Wow. We're back to square one. Lacking in substance. Lacking in argument. I found absolutely nothing that I think would sway in a meaningful way Court of Appeals judges. In this case, it's another PR stunt. It's another attempt to try and change the narrative. And that is it. So I thank you all for joining me. Have a wonderful and happy Thanksgiving. Go eat some turkey. And I will see you all tomorrow when we're going to be reading, hopefully, Amber's brief. Bye, everybody.